I've sought the consent method. May I have a slight accommodation? Next week. Next week. Okay.
Just what's the representative on the plan of the instance by council for the petitioner. Let's in the next week.
Next week.
6.
May please, Your Lordship.
Yes.
Lord, I pray for a listing of this contempt
Here for
petition.
listing, please give it to the court master. All please.
With regard to item number 63, and the consent Lordship, on behalf of Mr. S. Bharali, can it be taken after a week, Your Lordship?
Okay.
Item 63.
63.
You have taken consent of the other side?
Yes, Your Lordship. I informed the junior Kasim Mr. Chandiya, Your Lordship.
With consent of the other side, Mr. Edas,
On behalf of Mr. S. Bharali, Your Lordship.
Young Council, prays for adjournment on behalf of Mr. S. Bharali, Council for the private respondents.
Number 3.
Prayer is allowed. List after
A week, Your Lordship.
a week.
Much obliged.
My lordship, I'm extremely sorry. There is an interim protection that may be extended till the next date.
Implementation to next.
Obliged.
That's why I beg to mention item number 16, Lordship. It may be
1/6.
1/6. Matter will be taken up after 1 week.
List after a week is paid for by Land Council for the petitioner.
May please, Lordship. I beg to mention item number 19, my lord. Matter will be taken up next week, my lord. 19.
Same order,
Obliged.
90.
May present, Lordship. Lordship, I beg to mention item number 39, Lordship. Lordship, with the consent of the other side, Lordship. Lordship, matter may be adjourned for the day, Lordship.
You are for petitioner.
No, Lordship. Respondent number 6, Lordship.
Okay, with consent of the other side. Young Council for respondent to 6 pays for adjournment. Prayer is allowed.
Lordship, any date may be given, Lordship. Any date, Lordship.
After we give a date, after a week.
1 week.
Date.
Date reading. Reading.
Obliged, Lordship.
Yes.
Next.
May I, Lordship? Lordship, I beg to mention item number 73, Lordship. 73.
70.
I see now Mr. P.P. Dutta has some personal difficulty with the Lordship.
The prayer made by Land Council for the petitioner. List after a week is prayed for.
Obliged.
Lordship, I beg to mention item number 57. I have taken consent from the other side. Kindly, it may come after 1 week.
You are for petitioner.
Yes, Your Lordship.
Consent of the other side. Council for the petitioner prays for adjournment. Prayer is allowed. List after 2 weeks.
Obliged.
May I please, Lordship? I want to mention, Lordship, item number 43, Lordship. We're going to pass over 1 week, Lordship.
Okay, list after a week is prayed for by Land Council for the petitioner.
May please, Your Lordship, with regard to item number 22, my lord. I've taken I'm from the petitioner, my lord. I've taken consent from the respondent side, my lord. Due to some personal difficulties, it will come after 2 weeks, my lord.
Okay. With all sides are represented. On the prayer made by Mr. V.K. Barua, Council for the petitioner. List after 2 weeks.
Yeah, please, Lordship. Lordship, I beg to mention item number 62. Lordship, here the government side is supposed to file affidavit, but they have not filed it yet.
62.
Yes, Lordship.
No, but they have not made a prayer for adjournment. Please renew the prayer when it reaches.
Yes, Lordship.
The other side has not made a prayer for adjournment. Yes.
May please, Your Lordship. Lordship, I beg to mention item number 55, Lordship. Yeah, Lordship, the order is complied with, Lordship. So I may be allowed to do the same, Lordship.
Okay. Both sides are represented. Upon instructions, Mr. H. Talakdar and Council for the petitioner submit that the order of this court has been complied with. Therefore, he has instructions not to press this matter. On compliance, this matter stands closed.
Obliged. Should I pay for listing this matter?
Listing তাতে দিবি।
For withdrawal, item 76, supply list.
Have instruction to the utility liberty to file a fresh lordship.
Why Liberty?
Lordship, because some subsequent developments are there, lordship. So I should have to incorporate all these things. Lordship.
Upon instructions, Mr. K. M. Majumdar and counsel for the petitioner submits that due to subsequent development, his instructions to withdraw this writ petition and to approach the court again. Miss
I'll go with it.
R. Google, and standing also for the forest department is present. Matters is dismissed with liberty as prayed for.
March July.
Dismissed on withdrawal, liberty is prayed for.
Item 1 to 4 for motion.
Yes.
In this repetitions manner,
Before my
the challenge made in the repetition is the order of termination now.
Yes.
And the order of
Why this
termination,
is coming in motion column for so long?
My lord, because the second petition, which is letter item number 4, my lord, notice was not issued in that. Okay. And these two being connected, since they're coming up together for that notice of motion, and this being connected is coming up in motion. My lord, may I just give a brief history and how complex this case has become? I'll just put in.
now the order of
It's
termination,
okay.
my lord, that has been withdrawn, my lord. Order of termination.
There is a
has-
difficulty in that. Therefore, I was trying to say that this is one case, my lord, where even I am coming to my wits end as to how to tackle the matter. Even I am coming to my wits end, my lord, despite all my efforts. What has happened is this.
Termination of order of withdrawn and whole departmental proceeding, my lord, initiated against the petitioner that has been withdrawn, my lord.
Is thereby withdrawn to start the department proceeding afresh.
Afresh. Now, that is where the difficulty lies. I'll just explain that. Lordship will give me 2 minutes time. What happens is a department proceeding was initiated against the petitioner on the allegation that she produced a fake certificate or a manipulated certificate at the time of her appointment. We gave her a written statement to it. They appointed an inquiry officer. They started the inquiry proceedings. I came before this honorable court. On the inquiry report being furnished to me, I came before this honorable court. This honorable court held that the entire proceeding was vitiated because the inquiry officer had appointed the presenting officer and he had acted in a biased manner, and therefore the proceeding should come afresh from the stage of the show cause notice. They gave me another notice appointing an inquiry officer and a presenting officer and asked me to participate. I came before this honorable court saying that I am under suspension for so long. I am alleging bias. They are not paying my subsistence allowance. I cannot participate in the proceedings as said by, as laid down by the Honorable Supreme Court. They released my subsistence allowance up to a certain period and a verbal period being, I'm sorry, prior to that, this disciplinary proceedings were stopped. The inquiry was stopped. There was a stay. On my subsistence allowance being released and a verbal prayer, this Honorable Court directed that they gave them the liberty to change the inquiry officer without lifting the stay. They changed the inquiry officer on the same day, on the second day an inquiry report was furnished. On the third day, I was terminated. Even before the time for my giving a reply to the inquiry report came on record, I was terminated. I filed a contempt petition saying that there was a stay, could not have been done. Contempts are not replied to. I filed a fresh writ petition again, challenging the show cause notice till the termination, everything. That is the fourth case, my lord, the item number 4. Notice was not issued there. This honorable court was on the verge of issuing contempt notices for proceeding in the manner, proceeding the matter in the manner done so. Submission was made that we will withdraw it. Now they have withdrawn the termination. Prior to that, they had given another order saying that my suspension will continue. A terminated employee is continually in suspension now without a termination being revoked. Being pointed out now, they withdraw the termination order only. Now, my challenge to the show cause notice itself, where I'm alleging that they are already preconceived to terminate me. They have not replied to it. The first order in the fourth lordship will find it was fixed after
but-
3 months.
No, but incidentally, it is you who have supplied to us
Madam.
1973, 1973 1183,
Yes.
where the Supreme Court has held that the inquiry can de novo be held.
Yes, inquiry can de novo be held, but without reinstating me, maybe placing me under suspension, they cannot come up with a fresh inquiry, number one. There's a judgment of this honorable court matter in my own, where I had appeared. There's a judgment that without reinstatement, if required placing me under suspension, it cannot proceed on a terminated employee, number one. Number two, when my very challenge is to show cause notice on the basis of bias, if I can show bias, then the second show cause notice will not come to me. Termination
No.
has only taken away.
No, Mr. Majumdar, I don't think so. In this office order, it doesn't say that you are kept under suspension.
There
So
was,
once
prior,
they-
there was a prior order, on the last day, there was an order given. There was an order given on the last date that,
No, but this will supersede, always supersede.
yes. So
Department orders, so therefore, you are-
termination order being withdrawn, there has to be a consequential reinstatement.
this automatic.
Yes, but thereafter, if on the item number 4, if I can show biasness in the show cause notice which was issued to me. Show cause notice is also.
No, but you see, please consider the situation
Ma'am.
where there is a order which is withdrawing the dismissal.
Yes,
Now, this leads to closure of the other writ petitions.
the first writ petition, ma'am.
Maybe the last writ petition will remain,
Yes.
where notice has not been issued.
Yes,
Correct.
because the show cause notice was challenged.
So that's okay. So.
If
because-
they are withdrawing the show cause notice also, that show cause notice also,
No, sugar notice, they are not withdrawing.
they are not withdrawing, then they cannot go for a fresh.
Afresh, my lord, we'll start from the show cause notice.
That is not what this says. This is not what this order says, that they withdrawn the show.
Well,
Termination has been,
Termination will be withdrawn.
will
but
be
the
will be
department
withdrawn,
proceeding
and
remains.
they, to start the department proceedings afresh. Can they do so? When, my lord, I am challenging the very show cause notice on the ground of malice and malafide and biasness, that the authority is biased,
No,
authority is malafide.
you see, at this stage, when they have withdrawn it, it's only presumptive that, what you call, what would happen whether there is bias or not. Let us assume that there is a biasness. But still they are withdrawing it and they are starting the department proceeding afresh.
Afresh. From the stage of show cause notice.
If he makes a statement that it's from the
Yes.
show cause notice, repetitions may be closed. The contempt part matter remains to be decided what they did when there was. a
Because
stay
if
order
you are
pending.
agreed by this, we'll have to make a fresh challenge.
Yes. Now that I agree to. This a fresh challenge will come when they give me a fresh show cause notice or when they initiate the department.
Or they give you a notice to.
Appear before the.
No, to start afresh from the stage of show us reply.
Yes.
So in the last writ petition, we can merely adjourn it
Yes.
to await, we adjourn it area prayer to see how they proceed with it. Because if they are proceeding with the same show cause, then your earlier writ petition would have cause of action.
Yes. Anyway, the de novo inquiry cannot be done without a fresh show cause notice. That is the again laid down law by the Supreme Court.
But that's okay. Let them take a call. You're not educating them.
No.
Huh.
Because in my in item number 4, my specific
It's okay. We adjourn that challenge.
matters.
We take it up after 2 weeks. In the meantime, if they
Let us
proceed
see
with
what
that,
it-
you can always regard that there.
Matter.
This other writ petition has to close.
The other repetition matter, if it is closed, then the part of the content matter where they had proceeded,
Contempt-
that also has to be closed. That also has to either be closed or be condoned by
No,
this court.
once there's a contempt,
Because it was the contempt of an interim order. If this petition is closed, then the interim order will merge with the final order. Therefore, whether they committed a contempt of the interim order or not, that issued lordship would just either close the contempt case saying that since they've withdrawn it, we close it, we condone it and we close it. Or if lordship feels that no, they had done something which they deliberately did, then they have to answer, they've not even filed an affidavit to that, anything in that.
it's better to close it.
Whichever, I leave it to lordship. I'm just trying to find
Because
out the way, my lord.
once they've withdrawn it, perpetrating those things again will multiply.
So cause notice, it said
that why you should not be punished because you are guilty. It starts like that.
That's okay. You will maintain your challenge. So this will dispose of writ petition.
Madam, 6513
6513.
of 2023. Only
Only one writ petition. And
Lawsuits.
this to contempt we are closing.
out of the
WPC 19 would
would survive.
would survive.
Would survive.
And what is this IA for?
I was for modification of the interim order after the contempt petition.
That is withdrawn, madam, withdrawn.
And they have withdrawn it.
Okay.
May I pray only for an observation, the closure of this petition will not affect her pursuing the WPC 19.
But Mr. R. Mazumdar, learned counsel for the petitioner, as well as Mr. S. Munir, learned counsel for the respondents, standing counsel for the respondents. At the outset, the learned standing counsel for the respondents has produced a copy of office order bearing number dated 6/5/2024, by which, in supersession of earlier office order dated 4/4/2024, the dismissal order issued to the petitioner, Srimati Kalpana Mazumdar, UDA, within bracket, under suspension, bracket closed, of the Assam Khadi and Village Industries Board by the order dated 8/12/2023 is hereby has been withdrawn to start the departmental proceedings afresh. Next paragraph. The learned counsel for the petitioner submits that that by filing WPC 19 of 2024, the petitioner has challenged the show cause notice issued to her in connection with the departmental proceedings. It's called departmental or disciplinary?
We have terms as an inquiry.
In the inquiry proceedings initiated against the petitioner. First of all, he submits that there's no clarity in this in the office order dated 6/5/2024 as to whether the departmental proceedings would proceed afresh on the stage of the previous show cause notice. He submits that the closure of this writ petition would not have any adverse effect against the petitioner in the said writ petition. Next paragraph. In view of the subsequent development arising out of office order dated 6/5/2024, referred above, this proceedings is closed. Mr. However, with the direction that the area subsistence allowance and or area salary, whatever is due to the petitioner, shall be released to her within a period of 3 months. In a period of 3 months. Moreover, The withdrawal of this writ petition shall not cause any prejudice to the petitioner in the proceedings of WPC 19 of 2024. Next, the said office order produced by the Learned Standing Council for the respondents is made a part of record. Matter since closed in view of subsequent development.
One submission may be recorded from the so-called notice, earlier the persisting so-called notice, the departmental proceeding that is to be starting afresh, that both authorities will start from the stage of so-called notice. They will,
Oh, that is, here there is no clarity.
yes.
Because if we write that, then perhaps you will be stopped from from that stage. So since there is no clarity, that's why we have recorded his statement and then we have said
That
that.
may be recorded, the intent of what I'm trying to project, the intent of the authorities is to issue
Second paragraph.
so-called notice.
Mr. P.K. Murli, counsel for the respondents have submitted that as per instructions, verbal instructions received by him, the respondents intend to proceed with the departmental proceeding oblique inquiry proceedings from the stage of show cause notice already issued.
No, they will issue afresh so-called notice.
Sure.
This so-called notice, they will not take action on this so-called notice. They will issue afresh.
They will issue a show cause notice afresh. Just correct the language, no?
And will not act on this so-called notice dated 3/8/2023.
And they will, and they propose not to act upon the show cause notice dated
3/8/2023.
3/8/2023. Just look at that. Contempt. There are two contempt petitions. But Mr. R. Mazumdar and counsel for the petitioner, as well as Mr. P.K. Murli and counsel for the respondents. Next paragraph. In view of subsequent development by which the respondent, the chief executive officer of the respondent number one, by office order, same thing, by office from the census. To stop. In view of the said subsequent development, the court is inclined to close this contempt petition. To stop, however, without prejudice to the petitioners to challenge the consequent actions. This WPC 19 of 2024 by Mr. R. Mazumdar, counsel for the petitioner, and Mr. P.K. Murli and counsel for the respondents. Next, in view of the subsequent development, by which the chief executive officer of same this matter stands deferred for 2 weeks. Next, it may be mentioned that although the learned counsel for the respondents upon instructions has submitted that the respondents intend to issue a fresh show cause notice to the petitioner and that they would not proceed with the show cause notice dated
3/8/2023.
3/8/2023. But the learned counsel for the petitioner submit that in the order dated 6/5/2024, as there is no clarity on the point, I place that the matter be adjourned. First call. Next, accordingly, matter stands adjourned today. After 2 weeks, give a date. This is the motion column answer.
In item number one, my lord, since the submission has been made, they'll issue me a fresh show cause notice. I pray for the liberty to, I pray that the liberty will be there for me to take my legal remedies against that. show cause
That we have already been mentioned in the contempt order. In the contempt order, you have said consequential actions.
Contempt was only because they appointed the inquiry officer.
I
and the
understand,
proceeding.
but there we have mentioned that consequential orders we are at liberty to challenge.
I'm obliged.
So
24/5.
first of all, the pendency of litigation shall not be a bar for the petitioner to say any subsequent action taken by the respondents. If so advised.
22/5.
Okay, you want letter.
25 of Sunday.
Give a date. Tell us a date.
Can it be 28, my lord, 28 of May? Or 27 or 28?
27.
27, let it be 27.
27th. Okay.
$28.5.
Obliged.
No, not 20. 28 is
Hearing date.
hearing day. 27th. Oh, acha, not 27. 29th then.
29.
29th.
29th May.
27th there is a division bench.
Obliged.
Item 5 to 15 for motion.
Maybe law. This contempt petition, my lord, the petitioner or the engaged, my lord, family attendance. And they are also the member of the family that function. They approach this honorable courts, my lord. And this honorable court disposed the matter long back, my lord. And the relevant part, my lord, is 151, my lord. And when the petitioners and other dispose of, my lord, the respondent authority, my lord,
Just 151.
and they approach the authority, my lord, but they are not comply the direction of this honorable court, my lord. In meantime, my lord, some similar situated person approached this honorable court, file a contempt petition in 2019 and 2023. my lord.
Just a
So my humble submission, my lord,
just a moment.
your lord. Similar person may approach this honorable court, file a contempt.
Just a moment. But you can't issue a contempt notice. Your
Yes,
is barred by limitation.
there is a limitation, yes, that part is right, my lord, but the petitioner, the member of the some individual person, the office of this social.
No, you see, one wrong done, will
My
not,
2019 also, man, and 2019, and some of the petitioners, my lord, individually approached
no,
this.
that's
contempt
okay, you
of
see, but this
2023,
contempt
man.
petition, the issuance of notice in this 452 itself was wrong. Because if it is barred by limitation, we can't extend the period of limitation in contempt. Section 20 of the Contempt of Courts Act, we can't overlook. Although we have not issued notice earlier, that was that cannot be lawful. Therefore, it will not be a binding precedent.
Yes, situated person, my lords. Time, but that is right, my lord. Admit it, my lord.
No,
But
sir,
the
we
authority-
understand.
Authority, my lord, say.
We
without
understand
any
that there is an
provision.
order, but we can't do anything. It's if the contempt, because it starts with non-obstante clause. Contempt, section 20. It is gonna Contempt of Courts Act. Six months. Mr. We will be closing it, but give me liberty to read the matter if so advised. Section 20 cannot be overridden. But Mr. Chalil and counsel for the petitioner. By filing this contempt petition under section 12 of the Contempt of Courts Act, 1971, read with Article 215 of the Constitution of India, the petitioner has alleged willful and deliberate violation of judgment and order dated 23/10/2017, passed by this court in WPC 900 of 2013, along with a batch of similar writ petitions. Full stop. By the said order, direction is issued for payment to be made within a period of 6 months from the date of receipt of a copy of the order of this court by the respondents in the said writ petition. Full stop. Next, in view of the bar created under section 20 of the Contempt of Courts Act, 1971, prescribing a limitation for initiation of contempt beyond 1 year from the date on which contempt is alleged to have been committed. This application is expressly barred by limitation. Next paragraph. The learned counsel for the petitioner has submitted that in a similar writ petition, in respect of similarly situated persons, similar order was passed. The similar order, like order dated 23/10/2017 was passed by this court, and due to non-compliance of the order, notice has been issued in connection with contempt case C 452 of 2023. Full stop. Be that as it may, in the present case in hand, as the order which has been violated is dated 23/10/2017. It is found to be beyond the period of limitation according to the said. According to notwithstanding that notice was issued by order dated 31/7/2023 in con case C 452 of 2023. This condemnation stands closed. The disclosure shall not preclude the petitioners to take such steps as they may be permitted in accordance with law. We already have a copy of this order here. We are returning you this. Okay. So what happens to these writ petitions? These writ
Already
petitions.
disposed of it.
Yeah.
Okay, it's already disposed of it. This one borders method actually. On the view of the order, this will take money.
Oh, okay.
Others are orders method. Only take the honorable portion tag. So it was listed.
My lord, in other case, other cases, lordship. My lord, in other cases, my lord, the complaints report was awaited, lordship. Undertaking was given by the state respondents, lordship.
Lordship, in this matter, it came up for on 24th and 4 weeks were granted, Lordship.
Yes, yes.
And now it has 4 weeks were granted to place the compliance report regarding the payment, because Lordship, the payment has already been started. And most probably the payment might end also, but on 24th, we were granted 4 weeks. Now it has been listed today, Lordship.
It may be listed on the debt fixed, lordship.
They can also confirm if they have received the payment.
I have also to take some instruction from the petitioners whether the payment is made or not, lordship.
Okay, both sides pray for some time to obtain instructions as to whether the order of this court has been complied with or not. Next paragraph. Moreover, the learned counsel for the petitioner prays for some more time to take fresh steps for service of notice on the respondents. Next, list after 2 weeks to enable both sides to obtain instructions. First of all. If in the meantime there's the order of this court has not been complied with, the petitioner shall take steps for service of notice on the respondents. Our issuance of notice shall be subject to further orders that may be passed on the next date.
My lord, in case number 445 lordship. In other cases, lordship. Online.
In all other cases, you take steps if you don't get instructions.
Yes.
Orders for issuance of notice will be issued later on.
Lordship.
Actually, item
Alright.
15, response number 2 is already retired during the pendency of the conduct.
Item?
15,
Item 15.
response number 2 is already retired.
Mr. A, both sides are represented. Mr. A Das and counsel for the respondent number 2.
Two.
Some that
Now to be.
that
What is that?
the respondent number 2 has superannuated
Yes, sir. On 31st
On-
of March 2020.
31st March 2024.
Pune does more research.
So the counsel for the petitioner shall take note of the said submission and take appropriate steps.
Oblige, lordship.
Item 17.
May I please ask? Well, this matter is relating to construction at appointment.
Just now. But your petition, your father died in harness in 2012. We are 11 years past now.
Well,
My lord, that is also not the thing, my lord. This DLC has considered in 2016. He came in a writ petition in 2024. That is also a fatal matter.
Maybe it was not communicated to him.
yes, that is, at that point, lordship, to that effect, lordship, instruction was sought for. As per lordship, office memorandum, they are duty bound to communicate the same. With clear order.
No, but 20, after 11 years, we are not allowing it. The writ petition has to be dismissed.
Dismiss, my lord.
My lord,
This falls within that Debrot Tiwari, my lord, the case.
page 18, last paragraph. The office memorandum. My lord,
Page 18.
18.
Yes.
Well, last paragraph, while disposing of the application by way of rejection, clear speaking order shall be recorded stating the reason for rejection, and a copy of such order shall be furnished to the applicants. Well, they did not serve any copy, lordship, or any intimation to the petitioner. And
No, that's okay, but still it is 11 years past.
my lord, so far imperial order is concerned, as per their assessment, lordship, 5 vacancies were there. And total numbers of 5 vacancy under 5% quota is to be filled out. And 3 were in position. 2 posts were vacant. 1 post, lordship, has been considered. And 1 post is still vacant. Page, lordship, 30.
Page
Page 30, lordship.
0.
Minutes of the DLC, lordship. In the first table, lordship, page 33. Grade 4. 96 post. Man in position 84. 5% cadre strength, 5 numbers. 5% of man in position 4 number, and this next column, lordship, important. Number of posts already occupied on compassionate ground, 3. So 2 posts were vacant. And in the second list table, your lordship will find page 30, all the posts relating to grade 3. And page lordship 31, grade 4. Only one post has been considered, that is serial number 10.
Which
So-
page you showed us the vacancy position?
Now, the
Where is
vacancy
that?
position lordship page 30. In the first table. Serial number 2. Grade 4, total characteristic lordship 96. And as for 5% quota, lordship, it would be 5 posts. And 3 were in position. 2 posts were vacant. They have considered lordship only one post, that is page 31, serial number 10. And all other,
I don't get it. You see, come to the previous annexure 7.
my lord.
Annexure 7, your candidature was rejected
No,
in
lordship, not
2014,
rejected, decided to place in the next meeting,
next meeting.
my lord. That is page 27. Serial number 1, second table. Accordingly, in the next meeting, 2016, my claim was placed. My lord, we came to know only after getting the RTI information, lordship, page 32.
No, it's too late. Still, it's too late for the. Even if 2016 the meeting is held, now we are in 2024. After 8 years,
Let at least, lordship, they could have,
in view of the recent trend of judgments of the Supreme Court of India, we can't interfere. No, what was that decision?
Debabrata Tiwari, my lord. State of West Bengal versus Debabrata Tiwari. 7.5.
This is EIR.
2020 AIR, my lord. My lord, I have this
First citation is
2023, that is, my lord, I can pass over, my lord. I have this tab, my lord.
yes, we have got it. Hmm.
Debabrata Tiwari versus State of
Mr. Khan, will you like to close your petition? Well, Mr. M. Khan, learned counsel for the petitioner, and Mr. R. Dhawan is additional senior government advocate appearing for the respondents. The father of the petitioner, late N.K. Abdul Barik, ABDUL BARIK, had died in harness on 7/11/2012 while serving under the commandant, 14th Assam Police Battalion. Full stop. The petitioner had applied for appointment on compassionate ground on 16/7/2013. Full stop. The candidature of the petitioner was considered in the DLC meeting held on 23/5/2014. And in view of the and as the vacancy position of constable and grade 4 post did not allow, the candidature of the petitioner was directed to be put up in the next DLC meeting. Full stop. Accordingly, the case of the petitioner was put up again for the DLC meeting held on 24/6/2016. Full stop. It is projected that although in grade 3, post of constable, the cadre strength was 790 and men in position was 770, the 5% of the cadre strength was 40 and man in position, 5% of man in position were 39. And 3 numbers of posts were already occupied on compassionate ground. The and similarly in the grade 4 post, the total cadre strength was 96. Man in position was 84. 5% cadre strength was 5. And 5% of man in position was 4. Out of which 3 posts were already occupied on compassionate ground. The learned counsel for the petitioner submits that one clear vacancy existed in grade 3 and grade 4 posts under the establishment of the commandant, 14th Assam Police Battalion. However, his candidature was rejected by the said DLC meeting held on 24/6/2016. On the ground that the vacancy position being available, the candidature of the petitioner could not have been rejected. The present petition has been filed under Article 226 of the Constitution of India. Next paragraph. To explain the delay, the counsel for the petitioner has submitted that the counsel of the petitioner had submitted an RTI application on 6th RTI application, and in response to the said RTI application, the commandant, 14th Assam Police Battalion, disclosed in the RTI reply dated 16/2/2024 that the candidature of the petitioner was rejected. No, not rejected. Had forwarded to him the photocopies of DLC minutes for the year 2014 and 16 in respect of the petitioner. It is submitted that only on perusal of the said RTI reply, the petitioner came to learn that his candidature was rejected in the year 2016. Full stop. Accordingly, it is submitted that the respondent authorities had violated clause 10 within bracket D. So principle principle 10 subclause D. Oh, no, I'm mistaken. Clause 14, 24 within bracket D of the office memorandum on compassionate appointment bearing number ABP stop 50 of the 2006 part PT / 182 dated 1/6/2015. Next paragraph. The learned additional senior government advocate has submitted that applications for appointment on compassionate ground cannot be considered after a delay of several years, although the respondent authorities may have been at fault. And in support of his contention, reliance is placed on paragraph 7.4 and 7.5 of the case of State of West Bengal versus Devabrata, DEBA, DRATA, Tiwari. AR 2023 HP 1467 equivalent to within bracket 2023 bracket was 0 Supreme within bracket SC 191. We said paragraphs 7.4 and 7.5 of the said judgment is quoted below. Full stop. In view of the ratio laid down in the case of Devabrata Tiwari within bracket Supra, notwithstanding that the petitioner might have received the information of rejection of his candidature in 2016, pursuant to RTI reply dated 16/2/2024. The fact, but the fact remains that the petitioner has approached this court after 11 years from the more than 11 years from the date from the date when his father had expired. In view of the inordinate delay in approaching the court, the court is disinclined to entertain this requisition, and accordingly this requisition stands dismissed.
Item 18.
Make real loss. Because before taking up the petition, my lord, I'll make a prayer for my lord. I'm not pressing prayer number 1, my lord. As the lordship has already held that the petitioner is not entitled to promotion.
Just a moment. Mr. Saikia,
My lord.
in order to cure the defect, by an oral submission that you are not pressing it will not be sufficient. You have to strike down that prayer. Otherwise, this will be hit by res judicata.
Yes, my
Yes,
lord.
yes, ma'am.
Your
Then,
reputation-
in that case, my lord, I will, my lord, withdraw this writ petition, my lord, only with a prayer to, my lord, file a fresh one.
Yes, you can permit that. But Mr. I.S. Saikia and counsel for the petitioner, as well as Ms. M.D. Baral and standing counsel for the
Transport Department.
Transport Department, appearing for respondent numbers
1, 3, and 4, my lord.
1, 3, and
3 and
4.
4.
And
Yes.
Mr. P. Nayak, and standing counsel for the Finance
Finance.
Department, appearing for respondent 2.
Two.
Next paragraph. As the prayer number 1 is hit by the principles of res judicata, for which preliminary objection was raised and recorded in the order dated 26/4/2024, the learned counsel for the petitioner seeks to withdraw this petition and to approach this court again without prayer number 1. Stop. Prayer is allowed. Matters are dismissed and withdrawn with liberty is prayed for. However, the liberty is not in respect of just the prayer number 1 of this writ petition. Whereby,
Absolutely.
whereby the petitioner is claimed for being promoted to the next higher post.
Deeply obliged, lordship.
Supply item 77.
You see that they are living for the same matter.
Yes, same, it is only for grade 4.
That's great. So, what was the earlier repetition? Very fast orders.
My lord, 2337.
257
Yes, my lord.
of 2024. Same order. Here it will the disability will be visual impairment with benchmark disability. Same order, Mr. S.K. Roy, counsel for the petitioner. For government,
I appear for 1
Mr. D. Boral and government advocate appearing for respondent number 1 and 2.
Lordship, I am for 5, my lord.
No, serially with 3. Who's for 3? Your name?
PG.
D. Jain, then counsel for respondent number 3. And
Lordship, I am appearing for 4, 7, and 8.
4, 7, and 8, Mr. D. Upapanya, standing counsel for the department. 6.
Lordship, I will be responding.
Okay, Ms. R.M. Barwad and standing counsel for respondent number 6.
5 and 5.
You're for 5 also. Sandy Bora, standing counsel for respondent number 5. Medical board 8.
Lordship, I am appearing.
8 also. Okay. So all names
Yes,
have
sir.
given?
Yes.
Okay. Same okay. What is the date we have fixed for that day?
My lord,
What is the date we have fixed?
14/6.
14?
6.
6. Okay. Same date.
Only bench 4. The bench 3, it was the bench 3. Two double 3 7. 2020.
Item 78.
May I please your lordship?
Issue notice here. Mr. Singh,
Notice, my please. Notice.
you have G. Das,
G dash, lordship.
her Mr. G. Das, and counsel for the petitioner, and Mr. B.K. Singh, Leonard, standing counsel for the respondents. You see, from your synopsis and in your prayer, you don't understand what you are asking.
My humble submission is that
No,
my
don't make
reports,
submissions. If you are
My-
making a prayer, we should understand from your prayer what you are asking. From your synopsis, you must understand what you are asking. Please read your prayer, read your prayer
I'm
and tell
reading,
us what you are wanting.
I'm reading out the prayer, Lordship.
Please read.
Okay. I'll shut it down. If in the premises it is appropriate, prayed that the Lordship be pleased to admit this petition, call for record, issue focus against the respondent by written mandamus, or accessory shall not be issued against respondent number 3 for setting aside, causing the impugn order remarks made by the respondent number 3, or issue a writ in the nature of.
So when we find that impugn remark,
Lordship,
Prefer to
in
remain
page-
silent, my lord,
in
on
page-
this.
Page
I
94.
prefer to
Lordship.
remain silent because he is not specific.
No, no.
Which remark?
My humble submission, I'm coming to the submission in page 94, Lordship, annex
no, I'm not going to page 94, page 110, and then find out what you are trying to ask. The synopsis of the writ petition, as well as the prayer made in the writ petition, does not disclose the impugned order or impugned remark which is under challenge. So according to the writ petition stands adjourned. For 2 weeks, the petitioner is permitted to amend the writ petition to bring forth, to spell out the nature of order or remark impugned in this writ petition. Just add there. It may be mentioned that the learned counsel for the petitioner had made an attempt to refer to the relevant pages of the writ petition to disclose about the impugned remarks. However, if the synopsis and the prayer does not indicate the nature of challenge, the court is disinclined to read the writ petition to find out the nature of challenge made. Adjourn for 2 weeks.
My name.
Yes, what is it?
79,
Same disability.
This is for extension, my lord, the similar order, my lord, and it's in page 86.
What is your disability you have not spelled out in your?
Yeah.
What is the disability you have not spelled out in your
My lord,
synopsis?
here are, my lord, 26 petitioner, my lord.
27.
Their disability, my lord, I have a spelled out, my lord.
You write down in a
My lord,
paper and
paragraph
give
2,
to
my
us.
lord.
No, you write down in a paper and give it to us. No, this, we have to amend it. We're going to entertain this litigation with vague plea. If you are filing it for number of petitioners, you must spell out which is what. You can't say a general remark that they are in various category of hearing, visual and locomotor.
But
You're not
yes,
entertaining
it
big-
has been selected, my lord.
We don't know. Your petition doesn't speak. Petitioner number, if I am saying petitioner number 1 is suffering from what? There's no pleading. You amend your writ petition.
Or my lord, by additional, I may be allowed to.
You do whatever you want,
My lord,
but bring it on record.
The certificate, my lord. Disability certificate, I will
You bring it by affidavit.
give me some till then, my lord.
Huh?
Give me some time, my lord, till that.
No, whenever you bring it, it will come. We're just adjourning it.
But it will expand from today, my lord.
If you do it today, it will come today. If you file an affidavit today, it will come today. You want to bring it today?
My lord, it's.
So whenever you bring the registry will list, it will provide you that liberty. There are 27 writ petitioners in same as SK, right? Counsel for the petitioner. And same delegates for the respondents. Here it will be, government, Mr. D. Bora is for one, 1 and 2.
Lordship, I am for 3,
3, Mr. Upamanya,
standing council.
Standing Council of Health. 4 is, Mr. R.M. Barwa, then Standing Council for respondent number 4.
For responding 5, your lordship.
5, okay, for 5. 4 is you, is D. Jain
D.
for Standing Council for respondent number 4. There are 27 writ petitioners in this writ petition. How the nature of disability, the nature of specific disability of each of the petitioners is not clearly spelled out in this writ petition. Next, the Rand counsel for the petitioner prays to allow him to file an additional affidavit to bring the disability, nature of disability of the petitioners on record. First of prayer is allowed. As and when the said affidavit is filed, the counsel for the petitioner is at liberty to make a mention or have the writ petition listed. Correct?
Obliged, Lordship.
If you do it tomorrow, make a mention tomorrow, we'll permit you.
My lord, the validity will till today.
Hmm?
The validity of the list.
No.
Daily list item 20.
Please, your lordship. Senior counsel is in another court. Can you pass over the matter for the timing?
This is for, this appears to be for disposal.
Lordship, actually,
If it is for disposal, we take up the end of the day, if you have time. Yes,
Lordship, we have, if your lordship, no further instruction is received because they have
no
stated.
further
that
instructions is not required.
Required, yes, lordship, we have already filed affidavit, lordship, this is our stand, lordship, last.
No,
day.
that's okay. 2014 matter, we don't need any further instructions. We'll
Lordship,
take up the matter for hearing at the end of the day.
lordship. Deeply obliged.
Obliged.
21.
This is also for disposal.
Disposal, lordship, records were called for, so records are.
We'll take it up at the end of the day. This 14, 15 matters, we'll take it up today, but end of the list.
It's second half.
Pardon me?
It's second half. End of the day, second half.
Because we have to complete the orders and all, because if you start hearing, this will take some time. Hearing at this stage, we can't do the report.
Yes, lordship, the records are also there, so.
It's okay, we'll take it up. We'll try to take it up. 23.
May please, your lordship.
Yes.
May please, your lordship, my lord, here, my lord, petitioner was an employee of the respondents, my lord. Plantation Coast Development Corporation, he was put under suspension on 11/6/2019, my lord. And thereafter, my lord, on 8/11/2019, suspension order was revoked. I will take your lordship to page 12, that is the suspension order, my lord.
What
I'm
happened
appearing
is-
for the standing council
What has happened to the departmental proceedings, if any?
Your lordship, there were
No proceedings
no
pending.
proceedings were
nothing.
done, but your lordship may kindly peruse this order, which is passed in
If there is
WPC
no
number.
departmental proceeding, then this has to be quashed.
Yes, your lordship, this has already been decided in a different writ petition, your lordship. The same petitioner has filed a different writ petition.
Here, my lord, if your lordship permits me, my lord, my prayer is very limited, my lord. He was suspended, suspension order was revoked, my lord, and I was not allowed to join, my lord. And in the meantime, the petitioner was superannuated, my lord. And my prayer before your lordship, my lord, my retirement benefit for that period, my lord. With that limited prayer, my lord, I am before your lordship. And
No,
in
but
day-
that has already been allowed here in this one five five
no,
seven.
not that, madam, not that. That is a case of earned leave, my lord. Cause of action is totally different, my lord. That is a case of earned leave, my lord. Two petitioners was there, my lord. That was disposed of. And my prayer also before your lordship, my lord, for disposing of the matter with necessary direction, my lord.
I don't think, please read this order. I don't think.
I can provide a copy, your lordship.
Read this order.
This is a case of earned leave, my lord.
I don't know, but the order, you see the order, you are given full relief. There cannot be more relief than what has been granted to you.
So, my lord, in that line, this reparation may be disposed of, my lord.
Because you've already been given,
Yes.
although your case might have been for earned leave,
Yes.
but this court has given you what? It has given you entire thing.
Paragraph 7, my lord.
The court says, proceeds with the premise that the grievance of the petitioner is that in respect of their earned leave, they are not, respected due claims have not been disputed. Is not in a position to pay unpaid salary of the petitioner due to poor financial conditions. So they have now come to entire dues.
6, your lordship may kindly peruse.
So in that line, my lord, it may be disposed of.
Okay. Third, Mrs. A. Bhattacharya and counsel for the petitioner, as well as
R.S. Deori, your
Mr.
lordship. I'm T. Deori appearing on behalf of R.S.
Mr.
Deori.
P. Deori, learned counsel appearing on behalf of Mrs. R.S. Deori, standing counsel for
Soil Conservation Department.
Soil Conservation Department. For all the respondents?
All the respondents.
For all, appearing for all the respondents. Next one. The learned counsel for the petitioner has submitted that when this writ petition was filed, the petitioner was agitated by not allowing him to join service despite the order reinstating him in service. However, during the pendency of this writ petition, the petitioner is superannuated, and therefore she presses prayer number 2 of this writ petition for issuance of a direction upon the respondent authorities to release the outstanding arrear salary of the petitioner. Next paragraph. The learned counsel for the respondents had produced a copy of order dated 5/2/2024 passed by this court in WPC 1557 of 2023, filed by the wherein the petitioner herein is the petitioner number 1. First of all, although next paragraph, although the petitioner, the learned counsel for the petitioner projects that the said writ petition was only for claiming unpaid earned leave. But it appears from paragraph 6 and 7 of the said order that this court had directed the respondent to release the salary dues of the petitioners within a period of 90 days. Therefore, the court is of the view that the said order dated 5/2/2024 passed in WPC 1557 of 2023 would also encompass the claim made by the petitioner in para 2 of the writ petition. Next, therefore, this writ petition stands closed with a direction to the respondent authorities by reiterating, by directing the respondent authorities in terms of directions issued by this court in paragraph 7 of order dated 5/2/2024 passed in WBC 1557 of 2023. With time limit of 90 days from the date of receipt of certified copy of this order for sanction of the supplementary demand for the aerial salary of the petitioners. Same order.
24,
May it please your lordship. My lord, your lordship may peruse the order dated 10/9/2020.
Yes. Yes, review petition.
My lord, the review petition in that the review petition was subsequently dismissed. I was allowed to join, though in the writ petition, earlier writ petition, my lord, 261/2007, I was allowed directed to be to join on 21/7/2015, but they allowed me to join on 1/12/2020.
Yes.
So, my lord, that period that your lordship in the order dated 10/9/2020, your lordship directed that other service benefit from the date as paid for. So I am entitled. In the meantime, the review petition of them also got dismissed. So I am entitled to all this here. The service benefit that I was entitled to get from the date of the judgment of 21/7/2015 to 1/12/2020.
What is the date of judgment of 261?
My judgment date was
Lordship,
21/7/2015.
21/7/2015. So he'll get the benefit from that date.
Lordship, what happened, Lordship, in this case? That they, against the dismissal order, the petitioners approached this honorable court by filing the WPC 261 of the 2007.
Yes.
Lordship, and this case, this honorable court, while interfering with the impugned dismissal order, directed the respondent to pass a lesser dismissal order, there is so and so passed by the, and thereby directed to permitted to impose any other penalty except that of dismissal order.
Yes.
Against that order, Lordship, the BVFCL filed a review petition. That was defect, Lordship. There was some defect, and the earlier counsel, he returned back the brief, Lordship, and kept his at a home, Lordship. And pursuant to the petitioner also waited, Lordship. From 2015 to 2020, he waited, Lordship, and thereafter filed this petition 3 WPC, the incident writ petition, Lordship. And this writ petition, Lordship, Lordship has passed an ex parte interim order, Lordship, because the BVFCL notice was not issued to the BVFCL, Lordship, and Lordship has directed to reinstate him, Lordship, within 10 days. And that time, Lordship, the certified copy was served upon the respondents, and accordingly we have reinstated him on 1/12/2020. And on the basis pursuant to the reinstatement, Lordship, this review application was admitted. Now the review petition was dismissed, Lordship. So
Review
All-
dismissal order is, my lord, I'm placing the dismissal order.
review was dismissed on recently,
So
Lordship.
then
on-
you have to
Lordship,
you have to follow paragraph 12 of page 62.
Lordship, now issue is regarding the back wages, Lordship.
Back wages we already denied, but from that day,
No,
from this
Lordship,
order was
Lordship,
passed.
from 2015 to 2020, Lordship. Because the impugn the order by order dated 21/7/2015, Lordship, this honorable court has directed to
Mr.
pass.
Kalita, he will, by default, he will get it.
Yes,
That benefit cannot be.
but Lordship, only my submission, Lordship, regarding he also waited from 2015 to 2020. It's a public money, and for that, the Honorable Supreme Court has getting a judgment, Lordship, from JK Synthetic. It was held that for back wages, Lordship, he has to plead that for that period he was not employed anywhere. There's no pleading to that effect.
No, after the High Court order.
Yes, sir.
Reinstating him, directing him to be reinstated. What do you call?
It's not a automatic, Lordship, reinstatement.
They
but
filed a
because-
review, and every time I approached, they said there is a review pending.
But Lordship, from 2015, Lordship, if Lordship peruse the page 65, on 24/8/2015, the petitioner was intimated that about the filing of the review petition. And
No,
he
is it-
also
is it
he-
a fact that he did not, after this High Court order
Yes,
of 21/7/2015, he did not go to your office to be reinstated?
Lordship, we have intimated him on 24/8/2015 that we have filed a review petition. And thereafter,
Where is that? Where is that?
28
page 65.
65,
65.
Yes,
24/8/2015.
So he was asked to await.
yes.
No, I was asked.
But he also waited, Lordship.
Definitely,
He also
obeyed
waited
you.
from 5 years waited, Lordship. He also
It's
not.
okay. You see, you direct him to wait. You did not say till when. So he waited. He complied with your order.
But
Employer's order was complied with.
But Lordship, for full back wages, Lordship, the Honorable Supreme Court has
Has to
stated
wait,
that,
whether you asked him to wait.
but he is also.
No, do you say that waiting was not what do you call he did not disobey the employer's order was bad?
I don't. But
You
Lordship,
just have to say that the employees of this Brahmaputra Valley, they are permitted to
he is
violate
very
the order of
obedient.
the employer. You can't say that.
He is also now. He retired.
I retired also, man.
He also retired.
No increment, nothing was paid, man. Only a fixed salary. The date of reinstatement was 1/12/2020. After this interim order, I have to file a contempt application now. Then only they have reinstated me.
I'm also I'm only relying a judgment, Lordship.
Yes, please. Where is the reinstatement order?
Well, no,
Ah.
reinstatement, well, I'm talking about this is very much. No.
From paragraph 15 to 17.
Just a minute. Now, this reinstatement, we just said before this, did you award any punishment thereafter? No. No. So this will not be covered by this the judgment. It will be an exception to this judgment.
Because during that period, review petition was pending and review petition was dismissed on
No.
February 2020.
Mr. Kalita,
Yes.
although your argument is good, but you'll have to show us that filing of the review will operate
No.
as a
I
stay.
admit,
It's
I
not there.
agree.
So if it is not there,
It's
this
our
judgment-
fault, Lordship.
this
Fairly
judgment of
submitted.
2007 would not cover, would not help you. But this saves you only when there's a misconduct reinstatement. So when you give him a lesser punishment and you still have a finding of a misconduct, then it says that the backwages would not be automatic. This doesn't help you. If you're
Para
relying on this
20, I have
judgment.
stated, mal, para 20, that I was without having any salary or others. It has practically become difficult to maintain his family without any service benefit, including monthly salary for a long period of time.
You know this repetition.
When review petition was dismissed, Lordship, on that day, I prayed for department on the account that on one single day, Lordship, 2 bad order.
Where is that?
Because if review dismissed, Lordship, our case on the basis of only review petition, that was dismissed, Lordship.
No, that's okay. But
Yes.
where is that order of dismissal
Uh,
or review petition?
Lordship,
That I have given a certificate copy.
Huh?
I have given a certificate copy of this,
Oh, yes.
22, 24.
Heard. Mr. P. K. Roy Choudhury and counsel for the petitioner, as well as Mr. K. Kalita and counsel for the respondents. The allegation against the petitioner was that he had used a fake scheduled tribe certificate at the time of entry into service, which was also used for being promoted. Full stop. On the fake ST certificate being detected, comma, departmental inquiry stroke proceeding was initiated against the petitioner. And by order dated 18/12/2006, comma, penalty of dismissal from service was awarded. Full stop. The dismissal was challenged by the petitioner by filing WPC 261 of 2007. Full stop. This court by judgment and order dated 21/7/2015, passed in WPC 261 of 2007, was pleased to interfere with the dismissal order dated 18/12/2006. And permitted the management of the respondents to impose any other penalty except that of dismissal and removal from service as provided under subclause within bracket small d and within bracket small e of clause 39 within bracket small Roman 2 of the standing order for the Namrup unit of the Fertilizer Corporation of India, which is now the Brahmaputra Valley Fertilizer Corporation Limited. Full stop. It was further ordered that as the management has not received any service from the petitioner during the interregnum, comma, he shall not be paid any back wages on reinstatement. Full stop. Next paragraph. The petitioner had approached the respondent, the general manager within bracket unit of the respondent number 1 within bracket respondent number 3 bracket closed, and forwarded the certified copy of the order of this court passed in WPC 261 of 2007 full stop. From reply bearing number page 20, page 65, last page. So and so dated 24/8/2015, comma, it appears that the undated letter of the petitioner was received by the respondents on 28/7/2015. Full stop. However, by the said letter, the petitioner was informed that his case has been referred to their legal counsel for examination, and it was opined that a review application be filed. And accordingly, the management of the respondents had filed a review petition before this court on 18/8/2015, against the judgment and order dated 21/7/2015, passed in WPC 261 of 2007. The petitioner was requested to await the final decision in the matter. Next paragraph. The learned counsel for the petitioner has drawn the attention of this court on, in the statement made in paragraph 20 of this writ petition, to project that the petitioner had not been reinstated in service and has not been paid his monthly salary since 2015. Next one. It is further submitted that it is only after the petitioner had filed a contempt petition. What is that contempt petition?
496 of 2020.
Contempt petition being con case C 496 of 2020. That the chief personal officer of the respondent had issued a memorandum bearing reference number 002 BVFCI PERS PERS 1733 dated 1/12/2020 to allow the petitioner to join in the post of technician grade 1 within bracket INST full stop. This one is separate. Next paragraph. For contract of the learned counsel for the respondents has submitted that as the service of the petitioner was reinstated by order dated 1/12/2020, the petitioner is not entitled to any back wages without demonstrating that he was not gainfully employed between 21/7/2015 till 1/12/2020. So it is further submitted that prior to 1/12/2020, the petitioner did not make any attempt to join service. So accordingly, it is submitted that the petitioner would not be entitled to claim any back wages. In support of his submissions that back wages cannot be demanded without rendering any service. And that the claim for back wages cannot be automatic, the learned counsel for the respondents has placed reliance on the case of JK Synthetics Limited versus K P Agarwal and another, comma, within bracket 2007, bracket close 2 SCC 433. Next one. In this case, in this repetition, comma, the petitioner has prayed for a direction that the direction upon the respondent authorities to reinstate the petitioner with effect from 21/7/2015, comma, the date of judgment and order passed in WBC 261 of 2007. Next one. We note that the petitioner, by a letter submitted on 28/7/2015, had provided a certified copy of the order of this court in WBC 261 of 2007 to the general manager within bracket unit within bracket respondent number 3, which is admitted by the chief manager within bracket HR. Within bracket respondent number 4 by his letter dated 24/8/2015. Full stop. The respondent number 4 by the said letter dated 24/8/2023 asked the petitioner to await the final decision in the matter, which is related to the filing of the review petition on 18/8/2015. The review petition filed by the respondents, which was registered as review petition 62 of 2020, was dismissed by this court by order dated 20/2/2024. Full stop. Therefore, when there was no stay operating for implementation of the judgment and order dated 21/7/2015, passed in WBC 261 of 2015, uh, 261 of 2007. In the considered opinion of the court, comment is not open to the respondents to have refused to comply with the directions contained in the said order dated 21/7/2015. Next, the petitioner could only have given a representation before the respondent authorities to reinstate him in terms of the order of this court. And therefore, when the respondent authorities have asked the petitioner to wait till the final decision, we find that the petitioner, after waiting for a long period of 5 years, has approached this court by filing this writ petition. And it is projected that during the pendency of a contempt petition referred above, the reinstatement of the petitioner was ordered on 1/12/2020. What is the contempt petition number? What is it?
496.
496/2020.
496.
496.
490,
6.
20,
2020.
2020.
20.
Just find out the last order in contempt petition. Then contempt petition number 490/2020.
496.
496.
496. Okay, it's 96. Just see the final order.
Eleven 2022 disposal. It was disposed on 11/5/2022.
11/5.
11/5.
Mr. Roy, you see, this contempt petition was disposed of on 11/5/2022.
No. I was allowed to join in the year 2020.
2020.
2020.
2020.
2020.
But Lordship,
And
not
thereafter,
because,
my lord,
not,
this-
not because of contempt petition filing, Lordship. What happened, Lordship, when the review petition was sent me, Lordship, that time, this honorable court has directed, learned senior counsel, let essence of that you first complied with, then only we, admit the review petition. And, and
the whole
accordingly,
issue is, my lord,
learned senior counsel also there for the petition also.
from 15 to 2020, my lord, the review petition was kept defective.
That is, I admit, Lordship.
My lord, they have only corrected after the contempt notice was passed.
No, no.
They have corrected the review, then it was, in that case, my lord, I was reinstated.
To register 12/10. 12/10/2020. We don't have any continue about it. Hello.
Judgment is a control.
12/10/2022 registered facility and for about the content about
You also notice. From the order dated 2/9/2020 passed in this writ petition, that the registry was directed to track and to tag the record of unnumbered review application filed under serial number 259482 of 2015. First off, we also note that the registry had put up a note in connection with this writ petition.
In your lordship's order dated 10/9/2020, your lordship has.
Let's put up a note dated 5/9/2020. To inform the court that the unnumbered review application was lying at defective stage in the filing section, for which it could not be tagged with this writ petition. Stop. The said state of affairs is found to be recorded in the order dated 10/9/2020 passed by this court. First off, accordingly, as an interim measure, by an order dated 10/9/2020, this court had directed the respondents to reinstate the petitioner within a period of 2 weeks from the date of receipt of a certified copy of this order. and allow the petitioner to draw his monthly salary with effect from the date of receipt of certified copy of the order. And it was also provided that the interim order would not prejudice the right of the petitioner to claim reinstatement with the effect of the date of the order passed in WPC 261 of 2007. Therefore, the reinstatement of the petitioner by memorandum of the respondent number 1 dated 1/12/2020 issued by the Chief Personal Officer has come into existence pursuant to the order dated 10/9/2020 passed by this court in this writ petition. Next paragraph. The review petition, which came to be registered as review petition number 92 of 2020, was dismissed by this court by order dated 20/2/2024. Therefore, there being no impediment in the implementation of the judgment and order dated 21/7/2015 passed in WBC 261 of 2007, with no stay operating, the direction of this court passed by said order dated 21/7/2015 passed in WPC 261 of 2007 has to be complied with. Full stop. Next, the respondent authorities having postponed the implementation of this order by asking the petitioner to wait by their letter dated 24/8/2015. In bracket annexure 21, bracket goes referred above, it is not open to the respondents to insist that the petitioner should give a proof of not being employed elsewhere. Full stop. The petitioner is not put to notice to not to take any activity to sustain his livelihood. Full stop. The respondents have not explained that if the order dated 21/7/2015 of this court is not complied with for a period of almost 19 years, almost
5 years.
5 years. No, not 5 years. Now it is 5.
9 years.
For 9 years till date. How do they expect the petitioner to take care of his family, needs of his family? Next paragraph. The case of JK Synthesis Limited within bracket Supra, cited by the learned counsel for the respondents, is not found to help the petitioner in any the respondents in any manner. Full stop. The said judgment is not an authority on the point that by filing a review petition, there is a automatic stay of operation of the judgment and order of this court dated 21/7/2015. Full stop. The the ratio of the said case, comma, amongst others, comma, is that in cases of inverted commas, misconduct reinstatement, bracket closed, comma, when the court does not hold that the employer was wrong or that the dismissal was illegal or invalid, comma, the direction the discretion of the court to award a lesser punishment was held to be was held to have the dismissal valid and in force till the power of lesser punishment is awarded. Full stop. The 11th observation of the Supreme Court of India in paragraphs you said 15 to
15 to 17. Lordship.
15 to 17.
So in this case also misconduct was too close. And
Here, my lord, a lesser punishment was directed to be given,
but-
but they have not given me any punishment. And I have already retired from my service.
case 61, Lordship, our court has already stated that
Page 62.
the misconduct was committed at the time of promotion. Only issue was regarding the proportionality of the punishment.
The 15 to 17 are put below. Make it 15 to 19. 15 to 19. Next paragraph. In the present case in hand, the respondents have not been able to show that the reinstatement of the petitioner was a consequences of imposition of a lesser punishment. So it has been stated in the bar that the punishment provided to the petitioner was never revisited. And in the meanwhile, the petitioner has superannuated on
In the year 22.
He is already superannuated. First off,
Joining me.
under such circumstances, comma, the court is of the considered opinion that the respondents cannot deny the respondents under the unique facts and circumstances of this case, comma, cannot be permitted to deny back wages to the petitioner from from 1/8/2015 as the judgment of this court in WPC 261 of 2007 was served in their office on 28/7/2015.
No, 13 Lordship.
15.
15 Lordship.
Full stop. Next paragraph. It is clarified that the order of back wages is passed in this case, in this petition under the unique facts of this case, and therefore this order is not intended to be cited as a precedent. So accordingly, this request stands allowed by directing the respondent authorities to make payment of back wages to the petitioner from 1/8/2015 till 30/11/2020, comma, as the petitioner was thereafter reinstated by order dated 1/12/2020. Full stop. How as the petitioner has approached this court after a long gap of 5 years. We are granting you 50%. We grant the
And
petitioner
other service benefits.
50% of the back wages along with other service benefit, accrued service benefits. So 50%. Take a break and come back.
All right.
Hello, plus.
Item 25.
Thank you, Lordship. My lord, the petitioner is serving the Assam Rifle and is aggrieved by the non-consideration of his promotion to the rank of NAB Subedar GD, my lord. What happened, my lord, in the year 2015 to 2019, the petitioner was posted as a ERE duty in the Assam Rifle, my lord. That ACR has not been taken into the consideration for the promotion, my lord. My lord, kindly see case number,
Just a moment.
my lord.
Where is the order of the Meghalaya High Court you are referring to?
My lord, I have, my lord. In paragraph 5 of that order, my lord, they have submitted. And the verdict of the Honorable Meghalaya High Court is para number 13, my lord.
But there is a, after this, there is a Supreme Court judgment in 2022 saying that the court should not substitute its opinion, because if that is the criteria, you have not made a request to post you in this any of these places. You are in a static post. You have. You have got the
He was at the
22.
some rifle field intelligence unit, which is stationed at Shillong, Lordship. And when his unit
No,
was at
this order was set aside by Meghalaya. After that, there is a judgment of Supreme Court in 2022. Do you have any decision of the?
I don't
to-
know. It was not posted on Monday, Lordship.
Because otherwise, if you are not producing any other judgment, then this Meghalaya would operate.
In that case, that is in his transfer was in public interest in the Meghalaya case. And in this case, he was at his own request, Lordship.
Where is that?
Lordship find in paragraph 2 of the judgment, Meghalaya High Court judgment.
That is your only ground?
Petitioner was thereafter sent to headquarter
Just a
IGR.
moment, Mr. Chakravarti. There are any more grounds?
That is the ground, my lord. That ACR has not been taken into the consideration.
You are saying that the 3 ACRs were considered only?
Only one ACR has been considered, my lord. That the ACR for the 4 years has not been considered, my lord.
Okay.
That is as per our record of instruction that will Lordship find at page.
Just a moment, just 1 minute, Mr. Chakravarti. Please come to page 27, 26, in fact. Brief history of the case of your affidavit.
Lordship.
Come to Sapara 2.
Lordship.
You're not saying that he did not, at his request, he was continued. Because you see, Mr. Chakravarti, if that is your policy, No, you are saying in paragraph 8 otherwise. In paragraph 8, you say that he did not submit a representation.
Any,
No, but it is not required for him. It is not your
no,
department.
he never requested to send it back to the, his unit,
No. You see, this is a uniform force.
lordship.
Unless you permit them to make representation for transfer, he has not done it. Now,
He
you
was,
see,
he was enjoying a soft,
no,
soft
it's not a
posting,
question of
lordship.
enjoying. You have posted somewhere and I am here, comfortable. If that is the, you see, in the Assam Rifles,
Lordship.
you, in paragraph 2, you say that, you don't say that, he's staying in that, unit was at his request.
Lordship, paragraph, 4, lordship,
Paragraph 4.
inner page 7. Last line, lordship. The petitioner was sent to FIU on 15/11/2015 from
For his
31
verbal request.
on his verbal request for a
No,
tenure
that
of-
can't be, because then you have to show from the order that at his verbal request, he was retained. Verbal request will not do. Verbal request to whom?
to the authority, lordship.
No, there must be someone. Because you see, come to page 17 of your reply, page, internal page 17, running page 39. Paragraph 4 is partly from knowledge, partly from record.
Lordship,
So this person who has sworn the affidavit
lordship,
must say that he was present on the day when the verbal request was made.
lordship,
This deputy commandant,
lordship,
he does not say that on that day I was in the office and in my presence he told someone. And then the authorities acted on it.
lordship. That's true.
So if that is not the case, then we'll be bound by this. We will be following this Meghalaya High Court.
Lordship. But lordship, our record of instruction, lordship, note my objection to that,
Yes,
lordship.
yes.
Paragraph 20, page 23 in
Page 23.
internet page 23, lordship.
Yes.
I don't know the running page of it. Lordship, criteria laid down for promotion, lordship. From Havildar to Naib Subedar, we are concerned with this, lordship.
My lord, just a moment, my lord, kindly.
From Havildar to Naib
Naib
Subedar.
Subedar. The first, second, third, fourth column, lordship, ACR. Lordship, find it, ACR. Serial number A, 3 out of the last 5 should be not below high average, remaining 2 reports should not be below average. Out of last 5, 2 report must be from battalion or at ARTC's S or at NSG. Other than this, lordship, the ACR cannot be. He was at Assam Rifle Field Intelligence Unit, lordship. Though he is a part of Assam Rifle, lordship. That is the difficulty in lordship. Only posted at any of the 3 unit can be considered. That is the scheme of the for consideration of promotion, lordship.
So therefore, everybody who is sent to this units,
Lordship.
what do you call,
Assam Rifle.
battalion or to ATRCNS or
Lordship.
NSG,
Lordship.
they go by the representation.
Perhaps, lordship.
We are not saying anything. Because armed forces people, they are not permitted to make representation that I will go there and come here.
There's sometimes sent on deputation to NSG also.
No, sometimes sent reputation is not at his choice. It's not like the, not like another service where they can, do you permit transfer on request by taking the, what you call, because you see how deputation occurs in other service. There will be a vacancy in institution X. They allow, just because we do it for Shrestadar. So any person who is qualified to be a Shrestadar in any district court can apply for the post of Shrestadar occurring, say, let us say in Sonitpur. He can apply. So therefore, when he applies, he takes the consent of the employer. And then he goes. So if he wants to go to any other service, where it is permitted, then he will apply, take consent,
Parent department.
and then apply, and then formal consent is given. That is how.
Deputation X, Lordship.
Yes, in Assam Rifles, you permit that? I don't think so.
Maybe, Lordship. Right now, I can say, Lordship.
No, because your
Without
act is there.
inspection.
Assam Rifles Act is there.
Lordship.
It does not permit. Does it?
No,
I do not-
when everything is not covered by, under the Act, Lordship, they follow the CCS or in this case, this is the record of instruction, Lordship. That will, Lordship, find a page 18, inner page 18 of our affidavit.
In the page 18.
18. This is the record of instruction, Lordship. So, everything that is not covered by the rule, sometimes there with some OMs and all. Assam Rifle Record, Office Instruction Number 4 of 2002. Promotion policy, Lordship. This is the promotion policy. So similarly, there may be some policy on deputation also, Lordship. Right now, I can say. This, what I have shown you, Lordship, there's a part of that policy.
Okay.
Rest I leave it to Lordship, whether.
Your promotion became due when?
First April 2020, my lord.
1st April 2020.
From the rank of warrant officer to Naib Subedar, my lord.
From the post of
Warrant officer to Naib Subedar, my lord.
warrant officer.
My lord.
But Mr. V. Kumar, learned counsel for the petitioner, as well as Mr. B. Chakravarti, learned CEC appearing for the respondents.
Lordship, only one correction, Lordship. That page 25 of her, that what I shown is Havildar to Naib Subedar. This warrant officer to Naib Subedar, page 25. Serial number 3.
25.
47 running page.
47 running page, Lordship. Internal page 25.
Yes. WO to Naib Subedar.
Lordship,
Yes, ma'am.
that will be the relevant.
Please correct me if I am wrong somewhere. Mr. V. Chakravarti and CEC appearing for the respondents. Next paragraph. In brief, comma, the case of the petitioner is that he is presently serving as a warrant officer public GD within bracket general duty bracket closed in the Assam Rifles. Stop. Where is the promotion order? Which page?
17, my lord, of the petition.
17.
My lord. That is serial number 8, my lord, of his junior was promoted, my lord.
Okay. The petitioner project that he has come across a battalion routine order within bracket part Roman 2 bracket closed dated what is the date?
12 June 2020, my lord.
12/6/2020. Bearing in respect of unit that's 31 AR by which the respondent number 4, comma, who was stated to be junior to that of junior in rank to the petitioner, was promoted to the rank of promoted from the post of warrant officer to the next higher post of Naib Subedar, NAIB Subedar. Post of. The petitioner claims that he was senior in position to the respondent number 4. Post of. Thereafter, the petitioner had submitted a representation dated 15/5/2020 to the commandant, comma, 31st Assam Rifles. However, by a response dated 4/6/2020, comma, the petitioner was informed that his name was not recommended by the DPC for promotion due to lack of ACR. Full stop. In this reputation, it is projected that the respondents have arbitrarily not considered his ACR with effect from 15/11/2015 due to 14/12/2019, comma, during which period he was posted in the Assam Rifles Field Intelligence Unit within bracket ARFIU for short, bracket closed. It is projected that the petitioner has no control over his posting. And therefore, even if the petitioner has remained in the ARFIU from 15 for the period wherein ACR from 15/11/2015 to 14/12/2019 was made, comma, the petitioner could not have been denied his promotion accordingly. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has prayed for quashing of the promotion order of respondent number 4, bearing order number is 17, like that. I've underlined the order number. And for a direction upon the respondent authorities to consider the case of the petitioner for promotion with effect from 1/4/2020. Next paragraph. The learned counsel for the petitioner by reiterating that the petitioner has no control over this posting. And therefore, the ACR grading earned by the petitioner for the ACR period 15/11 2015 to 12 2019 would not have been ignored. First off, in support of his submissions, he has placed reliance on the case of capital IGE, SORA. Next is capital JC 113838 versus Union of India and others, 2019, SCC Online, MEG MGH 299. Copies here. Next paragraph. Per contra, the learned CEC. By referring to the affidavit in opposition filed on behalf of the respondents, has vehemently opposed the prayer made in this writ petition on the ground that as per the criteria for promotion of GD personnel, applicable for the Assam Rifles, which is annexed to the said affidavit in opposition as annexure Roman 2. It is submitted that for being considered for promotion from the post of warrant officer to Nayab Subedar within bracket GD, the criteria laid down is as follows. Page 47, flag. Serial number 3, only that much. 1, 2, 3, 4, 5 column. Accordingly, it is submitted that the stand of the respondents is that the posting of the petitioner at ARFIU is not entitled to be interpreted as an extraneous service. Accordingly, the said service cannot be counted for the purpose of promotion, as the ARFIU is an integral part of the Assam Rifles organization. It is submitted that the requirement of the promotion policy in the Assam Rifles, applicable for GD personnel. GD is general duty.
General duty.
GD, general duty within bracket GD personnel, is that out of last 5 reports, 2 reports from must be from battalion public ARTC symbol and S public NSG. Accordingly, it is submitted that the that on one hand, the petitioner had never made a representation for being transferred into any of these, the said three services. And moreover, the specific stand of the respondents in paragraph 4 within bracket Roman 4 is that the petitioner was sent to FIU on 15/11/2015 from 31 Assam Rifles on his own verbal request for a tenure of 3 years. And that after completion of the said tenure and after his reliever reported on 9/10/2019, the petitioner was reverted to 31 Assam Rifles. We continue to. Last submission. Accordingly, it is submitted that the criteria laid down by the Assam Rifles for promotion is not, cannot be violated. This is accordingly case for dismissal of the writ petition. Next. The there is no doubt of the fact that the petitioner is a member of the uniformed forces. And he's otherwise bound by the promotion policy of the Assam Rifles person. Being a the from the stand taken in paragraph 4 within brackets Roman 4 of the affidavit in opposition, wherein it is stated that the petitioner was sent to FIU on 15/11/2015 from 31 Rifles was as per his own verbal request. The tenure of 3 years exposes two situations prevailing in the Assam Rifles. First is that the authorities in the Assam Rifles have admitted that they entertain verbal requests for transfer and tenure. This itself is not in accordance with the prescribed guidelines, either on promotion or on transfer. It would have a ripple effect of ripple or cascading effect on the Assam Rifles as an institution for entertaining verbal requests for motion and transfer. Sorry, for transfer. Which means that the authorities in the management of Assam Rifles are resorting to encourage the uniform personnel under the Assam Rifles to make a verbal request. So there's nothing on record to show that there is a policy in the Assam Rifles for compulsory placing their general duty personnel to battalion within public ARTC symbolic and S of the NSG. Pushpa. Therefore, if personnel are not posted to these units like battalion, ARTCS, TCNS, like NSG, the Assam Rifles cannot be allowed to contend that they are mandatorily required to have 2 reports from those agencies like battalion, ARTC, NS, the NSG. Pushpa. It is not the case of the respondents that there was an order to transfer the petitioner to those units, but he refused. And at his request, the transfer order was modified to an order of transfer of the petitioner to a RFIU. Nothing is shown that no records have been produced to show that any entry was made in the service record of the petitioner that on verbal request he was transferred to ARFIU instead of sending him on this on deputation to battalion of the ARTC and S and the NSG. In the criteria for promotion of GD personnel, which is annexed as Annex Roman 2 to the affidavit in opposition filed by the respondents. Which require that the GD personnel should apply for being deputed to serve in any battalion of the AR, ECA, and S of the NSG. Therefore, having transferred the petition to ARFIU, what is in the Assam Rifles? We are aware that the petition is posted for 3 years to the ARFIU, he would become ineligible for promotion. It is not in dispute that the petitioner had received only one ACR from the 31st Assam Rifle Battalion. The 31st Assam Rifles. And the last 3 years while he was serving at ARFIU, the ACRs were made by the state authorities. Mr. Singh, please come to page 22. Here also they have informed you that it was at your own request. Have you denied that you made a request for the ARFIU? Page 22.
Of the requisition value?
They have informed you in 2020 that you were sent to FUI on your request. Have you denied that? What was your tenure in this ARFIU? What was your tenure from which date to which date you were there?
That is, my lord, 15 November 2015 to 14 December 2019.
Where are you now?
Now I am in 31 Assam Rifle.
But you see, whatever finding I have recorded till now, you have almost demolished it brick by brick. if I'm reading page 22,
My lord.
this is a proof that you gave a verbal request to them to transfer you back. That means verbal, you're yourself giving a verbal request. So if there's a verbal request which is permitted, then perhaps your ACR criteria was rightly applied. If this is your letter, no, sorry, not that. You made a statement here. You made a statement somewhere. Yes, paragraph 7 of your repetition. At page 6.
My lord.
Now you make a statement that after completion of his tenure,
My
you
lord.
requested the commandant that he is completely willing to return.
My
You
lord.
have not submitted any letter. That means Assam Rifles do entertain verbal requests.
First, my lord, he has made the verbal request to return.
Once you
from
make a
the-
verbal request, there's nothing on record to show that you made a verbal request to be posted elsewhere. You know the promotion criteria.
My lord.
If you know it and you are permitted to make verbal requests, non-giving of verbal request will be against you. That Mr. Chakraborty is right. Your reputation will be distinguishable from that decided by the Meghalaya High Court. Because it's your own pleading that you made a verbal request.
My lord. But the thing is that, my lord, once the lever is not reported in my place, that's why the commandant.
That means everything is happening verbally,
My lord.
and you have accepted that. So therefore, you are aware that if you don't go outside, you will be in trouble, and you invited that trouble. You see, page 22. In 2020, you were informed that you went through this in verbal request. You have not denied in the repetition. So the dictation which you are giving in your favor, you have demolished it brick by brick.
My lord, I was sent on ERE duty for the 3 years on.
No, that means you take a decision.
My lord.
You have taken a conscious decision to be out for 3 years. So you have missed that criteria. And you are informed not now. In 2020, you are informed that you are going at your own request. You have not denied in the repetition that there was no request made. Then the repetition has to be dismissed. We'll have to distinguish Meghalaya. No, the repetition has to be dismissed.
My lord, then whether the request is made verbal or written, then I will take instruction.
No. Once you start dictation, that is not. I've just asked you out of courtesy. I'm not required to ask you, not required to tell you what I'm doing. But since I had been started the dictation of that presumption, and when I was dictating and reading it, I find in paragraph 7 you took a stand of verbal. So how from the things made in paragraph 7 of the petition, it appears that the petitioner has taken a stand. I mean, it is seen that the petitioner has taken a stand that after completion of his tenure, he requested the commandant, ARFIU, that he had completed his tenure and was willing to return to his unit. Full stop. It is not in dispute that the petitioner had completed tenure of 3 years in ARFIU for the period from 15/11/2015 to 14/12/2019. From the documents annexed to the petition, it is also noted that in response to the letter dated 15/5/2020 by the petitioner claiming his consideration for promotion, the competent authority of 31 Assam Rifles by a letter dated 4/6/2020 within bracket annexure 6 bracket closed, had informed the petitioner that on 15/11/2015, he was sent on ERE duty for 3 years at his own request. And after completion of 3 years, he was not returned to the unit. And that the petitioner had not even submitted any written application the last 4 years, 1 month to return to the unit. Therefore, from the pleadings made in paragraph 7 and from the contents of the reply dated 4/6/2020 within bracket annexure 6, it is evident that the petitioner was transferred at his own request to ARFUI. Therefore, with the promotion policies in force in respect of GD personnel, it is expected that the petitioner would be aware of the criteria for promotion of GD personnel from the rank of warrant officer to Naib Subedar within bracket GD. Therefore, the court is of the considered opinion that the petitioner took a calculated risk to make a request transfer to ARFUI, which is within the establishment of Assam Rifles, which would not qualify the petitioner to be considered for promotion in terms of clause C of the promotion policy, which is already extracted herein before. If the petitioner can be transferred at his own request and re-transferred at his own request as per pleadings made in paragraph 7 of the petition, there was no bar for the petitioner to opt for being transferred to battalion within bracket, oblique ARTC&S oblique NSG. Next. The case of IGE Sora JC 113838 within bracket super cited by the petitioner would not help the petitioner in this case because of the fact that it is not a case where the petitioner was compulsorily transferred to ARFUI, contrary to his request to be transferred to battalion of the ARTCNS of the NSG. The petitioner is not denied the correctness of his stand taken in the hearing before referred. Letter dated 4/6/2020 by the competent authority in the 31 Assam Rifles, wherein it is stated that the petitioner was sent on ERP duty to ARFUI at his own request. Next, therefore, comma. Having availed on request transfer to ARFUI. The action of the responding authorities in transferring the petitioner to the said unit cannot be said to be arbitrary or illegal. And it cannot be held that the said transfer was made to deny any promotion to the petitioner. From the pleadings made in paragraph 7 of the petition, it is clear that the petitioner made a request for his transfer back to the battalion after completion of 3 years tenure under the commanding ARF. It is FIU or FUI? You are interchangeably using
Assam Rifle Field Intelligence Unit.
IU. It will be IU. You said down. The petition fails and the same is dismissed. Next, how the court parting with the records. Now the court finds that the practice followed in the Assam Rifles to entertain verbal requests for transfer and posting makes the entire process questionable and subject to judicial scrutiny. So therefore, it is left open to the authorities in the Assam Rifles to take corrective measures so that the members of the uniformed forces are not discriminated by entertaining such verbal requests. It would be a policy decision and left open to the authorities to decide.
There must be some SOP.
No, but this can't be encouraged.
Yeah, they can be encouraged. Oblige.
Item 26 to 31.
Yes. Mr. Dasgupta, this is going to take some time.
Yes.
We'll take it up after some time because there are two matters I have.
Or
postponed from.
can you take it day after tomorrow?
No, because every day will be the same occasion. Here, what has happened, 2015 and 14 matters, I have deferred for some time.
All right, let it be there for tomorrow.
Yeah, no, it's the same thing.
No, my lord, day after tomorrow.
Yeah,
I have some
tomorrow is also
difficulty.
same position. We already have more than 50, 60 cases.
All right, I'll be here.
Just wait for some time.
No problem.
If I can begin. It will depend, Mr. Dasgupta. And
No, I'll be here.
you see, please try to understand what I'm trying to say. If this 2014-15 matter falls for some reason, then we'll take it up. Otherwise, we'll accommodate your date. Because you don't know when we start. Otherwise, also it's a long list. This 2014 matter, this why I've taken up. Please wait for some time. Manage the board and then take it up. Do you have a list of dates prepared in these cases? You have prepared a list of cases, list of dates,
List of dates.
list of dates.
No, I don't. Okay.
Will it be required here? Because there are 5 or 6 petitions.
My lord, I don't think, my lord, so far as I'm concerned, my lord, this is a narrow compass, my lord.
No, according to according to him, narrow compass, according to me, broad compass. All right, no, without list of dates, let me try, if not possible, actually. Or the day after tomorrow, or any date.
Just see if I can accommodate.
Your lordship.
Otherwise, I'll declare.
Your
I'm not asked to wait.
Item 32 to 34.
May I please, your lordship? Okay, in item number 32, my lord, that is WPC 5482, my lord. Here we have asked for the seniority. Regarding this, my lord, advertisement was issued in the year 2007 for the appointment to the post of sub-inspector of police, UB, my lord. And what happened, my lord, we have also participated, the petitioners, in the selection process, my lord. And the later on, my lord, we came to know that there is some anomalies in the select list, my lord. Therefore, we have approached this honorable court. Accordingly, my lord, during the, my lord, pendency of the petition, my lord, state authority has admitted that there are some anomalies in the select list. Therefore, they have agreed to redo the select list. As per the order of this honorable court, my lord, they have redo the select list, my lord. In the year 2014, the order was passed. And in the year 2017, my lord, we have appointed along with the 53rd, as a 53rd batch, my lord. But the advertisement was for the 49 batch, my lord. Therefore, my lord, in this repetition, we asked for the seniority along with the 49 batch, since the advertisement was issued for the 2007 in the year for the 49 batch, my lord. My lord, in this repetition, we have already subsequently got the relief, my lord. In the second repetition, I have quoted, my lord. Therefore, it's become infructuous, my lord. First one. My lord, as per order date 22/03/2023, my lord, I have annexed, my lord. In the second petition, they have given the seniority, my lord, with the 49 batch.
Counsel for the petitioners. Petitioners, upon instructions, has submitted that going to subsequent development. For which the petitioners have filed WPC 3835 of 2023. This requisition has become infructuous.
No, my lord, WPC 5482, my lord. This is the first one, my lord. Item number 32, my lord.
Yes.
That one become infructuous.
That's what I'm saying. I'm passing order in the first matter.
Yes, my lord.
Mr. R. Leonard, additional senior government advocate. You're appearing for all the respondents? Yes, ma'am. Response present. According to this circumstance, dismissed, having not pressed. Having not been pressed. The dismissal of these repetitions shall not prejudice the petitioners. When the connected WPC 3835 of 2023 is heard. Okay. This is one.
In the second one, my lord, they have not filed the affidavit yet, my lord. It needs to be filed. In the second one, my
They're
lord,
not contesting it.
in the second lead petition, my lord.
In the first, we have filed affidavit, my lord. That
Second,
is,
you are not contesting.
second, my lord. No, my lord, we are contesting, my lord. My lord, we are yet to file affidavit, my lord. In this matter, I have received a written instruction. They need some time, my lord. The authorities written to me, my lord, that they need little further time
No.
to send.
You see, there's a gap. In the first petition, you have filed a document saying that in 2021,
My lord,
they have undergone a training process.
My
And therefore, you'll inform the court what has happened thereafter.
my lord.
But from 2021 to 2024, you have
My-
not informed us whether they have successfully undergone the training. And number two, you have not also informed if they had participated in the recruitment process in the first, what do you call that, recruitment drive of
49 batch, my lord. 49 batch.
9 batch.
My lord.
Why they will not get the benefit of their seniority position from that date?
My lord, that is what, my lord, we are yet to file affidavit in this, my lord. I am not, I have not received that instructions, my lord, from the department, my lord. They short for some time, my lord. That is what I'm praying for. The first matter, item number 32, my lord.
That request for time has come to you when? What is the date of that letter? 23,
23, my lord.
23. So for this year, you have not received the
My
request.
lord, the matter has come after a long time, my lord.
No, I
Sometime it overlaps, my lord. We have, my lord, sometime it happens, my lord. So my lord will fix the matter
No, but
after two weeks, my lord. In the meantime, we'll file affidavit.
don't take a chance. When the matter is listed, inform it 1 day in advance to the court master, because if I spend time,
My lord. My lord,
I'm wasting my time.
no, my lord, the matter was, matter was tagged, my lord. Tagged, my lord. So in the past, we have filed affidavit, my lord.
No, you do some homework and then come. Because if I read the file in the meantime. There's a-
My lord, after issuing notice, it is coming for the first time, I think, my lord.
How much time?
My lord will grant with 2 weeks time, my lord.
Okay. Both sides are represented. Mr. R. Dhawal and senior government advocate. Raised for 2 weeks for the time to obtain instructions and file affidavit in opposition to the matter. This is item
33 and 34.
33, my lord. In the 34, my lord, we have taken steps upon the private respondents, my lord, which are 5 to 78, my lord. As for Lozima, my lord, there we have to take first step upon the respond number 8, my lord. Which is not served. My lord, Lozima, my lord, the order dated 13/02/2024, my lord.
Only 8 you have to take again.
Yes, my lord, I have
All
to take.
others are.
Others were served, being served.
Okay.
But this was not there, my lord, we have to take through respond number 3, my lord. Here, my lord, we have challenged the promotion, my lord, which are junior than us, my lord. 51 batch, my lord.
Person to office note dated 1/5/2024. Mr. Hazarika counsel for the petitioners praised for and granted 2 days time to take steps for citizen notice and respond number 8.
We will also file affidavit, my lord, in this manner.
Oh, okay, notice is made returnable on due date after 4 weeks.
7th of June.
My lord, in the
Counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal tract report prior to the next date of listing. Affidavit in opposition by the respondent, they file 2 days prior to the next date of listing. Both the cases gave the same date.
my lord, there is an interim order in item 34, my lord, in the last
34.
34.
Interim order passed release stands extended till the next report.
I'm deeply obliged.
35.
My privilege, lordship.
May I please, my lord?
Just now, no?
Yes.
Just now.
My lord.
Yes.
Yes, my lord. As per the earlier order, my lord, we are supposed to produce the original records, my lord, today. There is accident in the premise of the APDCL, my lord. Sometime maybe accommodate, my lord, for us.
You filed your affidavit.
Yes, we have already filed an affidavit, my lord. In the affidavit, my lord, there is an annexer A, my lord. To authenticate the annexer A, my lord, we are supposed to produce the original records.
That annexure, where from they brought it from, where they have extracted it, who has issued it, nothing was there. That's why
Yes, ma'am.
this honorable court has directed to produce the original copy from where they have extracted it actually. That annexure from page 56.
Okay, both sides are represented. Mr.
Midas, my lord.
Bidas, and you also have the DCA. Yes, sir. Means that last week, fire incident in the APDCL complex, for which the original records could not be produced. On his period, the matter stands adjourned today. List of the date up to 2 weeks. This one should also for production of not for compliance of the order dated 19 to 2024. To produce the selection records. 2 weeks. Take the data.
Yes, my lord. I'm obliged.
Not so good.
Item 36.
Lordship, in this case, I was supposed to file an affidavit, Lordship, because the annexure B of my affidavit was incomplete. I have received the Lordship, the affidavit today only. That will be taken up Friday or Monday, Lordship. I'll be able to file it by tomorrow, Lordship.
Next Monday.
My lord, on Friday then. But my lord, I have a submission, my lord, only because of uncommunicated ACR. Because of uncommunicated ACR, my lord, I was not given the second MSCP benefit. They have admitted in their affidavit.
So let us see, but if they are filing an affidavit, we can't wait them. Also, a representative, Mr. B security on CDC submits that DSC. You would be filing the affidavit in opposition. So additional affidavit.
Additional affidavit.
In opposition. By tomorrow.
By tomorrow.
By tomorrow. By 9/5/2024. This one 10/5/2024.
37 with 38.
Okay, Your Lordship. Lordship, my senior Mr. H. Puragohai, today he is unwell. Matter may be adjourned for today and list after
You
1
file an
week.
affidavit.
We have filed our affidavit, ma'am, and they have filed
Lord, we have
reply
filed a
also.
reply.
For
Yeah.
in item number 38, my lord. Affidavit may be stated as
37, you are not filing anything.
no, my lord, the
affidavit in opposition file in 38, item number 30, that may be treated as common affidavit.
Both sides are represented. The unit counsel for the petitioner pays for adjournment. Mr. D.K. Roy and the standing counsel for the
Respondent 7.
for respondent was 7. Submitted that an affidavit in opposition has been filed in WBC 2831 of 2023. And it is submitted that they said affidavit shall be relied on for the purpose of this petition. This is 2989, first. First. Next one, on the prayer made by the Union Council of the petitioner, the matter stands adjourned today. Just after,
1 week.
just after.
My lord, if possible, fix any date.
What is the subject matter? What is the subject matter?
My lord, regarding the recruitment of grade 3 and grade 4.
Recruitment. We did next week.
17th of May.
40. Just this matter on so. In terms of order passed in WBC 2829 of 2023. Yes, 40.
Lordship, item number 37 and 38, Lordship. There is Lordship, state level recruitment commission is there, Lordship. So there is a standing also, Lordship. Kindly show the name of SC conducts this, Lordship. State level recruitment commission, Lordship. There is another standing council, Lordship.
The registry shall reflect the name of SC,
State level recruitment commission, Lordship.
SL.
SLRC. SLRC.
The cause this by listing in the next.
Item 40.
Yes, Lordship, we have to resubmit the pension proposal to the AG, Lordship. And it is in the process. In fact, Lordship, the executive engineer had submitted to the chief engineer, Lordship. And the office of the chief engineer is going to submit in the, Lordship, 2-3 days, Lordship. It is to be resubmitted in proper format, Lordship. This is the submission of the learned AG, Lordship. Advocate, sorry. Accountant, accountant.
Strange, you're such a big department, does not know how to fill up.
2-3 occasions we have Lordship, that is our fault is there, Lordship. Lordship, it's a matter of 2 weeks, Lordship, in the meantime.
You are appearing for accountant general. Mr. Nayak, you are for finance.
Yes.
You must have a training to this department, accountants, how to send proposal for family pension.
Lots of the concerned department will forward it to the.
No.
Training, finance will have to give them training, how to write applications.
One form A, form B is already there.
No, I understand. Forms are there, but they must be educated how to write. Now, who will do that?
Now it is in the proper format, Lordship, it will go, it will be submitted.
Okay, but one round of writ petition since 2023
Lordship.
Lordship, an application and
and
it died, Lordship, in the year 2019.
19.
Initially, Lordship, whether she is unmarried or not, the petitioner is
All the
unmarried daughter or not, that was in the question, Lordship.
Lordship, in the year 2021, first Lordship proposal form was submitted along with all the documents, Lordship. Then Lordship sought for some clarifications. In the year 2002, again submitted, and 2023.
You see, family pensions are property. Once it is a property, it must accrue interest.
Family pension she is receiving. She is only claiming compassionate family.
No,
That is the full
Compassionate.
No, Lordship, that is wrong, Lordship. Lordship, what happened, Lordship kindly come paste.
It's okay, that
yes.
is what is your case.
Lordship, no, Lordship, still Lordship.
My
whatever
friend knows
platform is
lordship, it is in the process
approved.
of submitting to the AG, Accountant General.
No, but what is that? Because you say the question of interest will come. Once
Yes.
family pension or others is a property, then delivery of property would enter interest.
Lordship, we have taken our steps, lordship, some
Okay,
time.
how much time?
2 weeks, lordship.
2 weeks.
Lordship.
Okay, both sides are represented. Mr. N. Upadhyay Lanet.
N. Upadhyay, lordship.
N. Upadhyay Lanet, Standing Counsel for the Irrigation Department submits that the error in submission of the proposals in respect of the petitioner has been rectified in a proposal which is correct in all aspects have been sent to the Office of the Accountant General for
Finalization of pension, lordship.
finalization of pension. Taking note of the submission made by the Learning Council for the petitioner that the predecessor in interest, father,
Yes, Lord.
the father in predecessor in interest had died on
Lordship 3/11/2019.
3/11/2019. The court hopes and trusts that this time the proposal will not contain any error.
Lordship.
This after 2 weeks, awaiting further instructions from the irrigation department.
Lordship.
Give a date after 2 weeks.
24/5.
Give a date, fix it. Not, don't say 2 weeks. 41, 42.
Highly obliged, Lordship. Highly.
Obliged, lordship.
Item 41 with 42.
May I please your lordship? Lordship, the council appearing for this matter is on legs. The matter may be taken up after some time.
Lordship, notice was issued, they had to file as per the.
Maybe they are considering.
Yes. Deeply obliged.
Bless you, lordship.
Item 44.
Yeah, please, Chair. My lord, in this case, I am entitled, my lord, under this judgment, my lord. Page 38, my lord. The Upendra's judgment, I am entitled, my lord. I have not been provided minimum pay scale.
You are working as, in what position?
My lord,
You're working as,
I am working as, my lord, casual employee, my lord. Kindly see, my lord, that
but if it's casual, you will not be entitled to that benefit of Upendas.
yes, my lord, I am entitled for benefit of Upendra.
How?
How, my lord, I have been working since 1995, my lord.
No. This Upendas was only for the works department, saying that they were muster roll workers.
Master roll, casual and.
Master casual.
Master roll, casual and similarly placed.
Casual is also
yes.
covered. Then anything you have to say?
Lordship, we have received our instruction. Lordship, one sunset clause has been set by the department. This judgment was passed in the year 2017. And the benefits were given from 2007, Lordship. Departments were asked to submit their proposal, I mean the list, within a specific period of time, Lordship. Thereafter, Lordship, the finance department decided that henceforth no more proposals shall be considered. That is the stand of the finance department, Lordship. I have received instruction to that regard, Lordship. Lordship will allow me some time to file this affidavit.
Because
Lord, in this regard already.
you can't have a, it apparently appears that you can't have a.
It cannot be continued, Lordship. Because the eligibility date is fixed, Lordship.
Deputy Commissioner,
2007.
Deputy Commissioner filed, District Commissioner filed affidavit already, my lord.
We have filed it on 22nd.
That's okay.
But finance department has to take the main.
Because apparently you, this can't be done without notice to all.
Lordship, I'll file one affidavit.
Also, it's represented. And the claim made by Mr. P. Nayak, London Chronicles for the Finance Department. List of the 2 weeks, so it's willing to file affidavit in opposition in the matter.
Lordship.
At date may be fixed, my lord.
Or you make a mention.
Obliged.
45.
May please, Lordship. Lordship, I am appearing on behalf of respondent number 5. My lord, 2 weeks time may be granted for filing affidavit in opposition, my lord.
Also, it's represented on the clear made by Gujarat Council for respondent number 5. List after 2 weeks, so it's to enable number 5 to file affidavit in opposition in the matter. Give a date after 2 weeks. 2 weeks.
Interim order may continue.
Interim order passed to this and extended with the Minister of Assembly.
24/5.
24.
Obliged.
Item 47.
Your Lordship.
You are from Union of India?
Yes, sir.
Please button up your coat.
We will
Button
file.
up your coat. Button up, button up. You're not button up your coat. Yes.
I'm appearing for the respondent. We will file the affidavit. Please grant us some time, like 4 weeks. Already we have waited 4 weeks time, Lordship. Short meet, date meeting.
Also, the represent. The claim made by the Learned CGC. How much time?
4 weeks. Much short date may be given, Lordship.
4 weeks. Why such a long time? You've already got 3 months. Make it 3 weeks. Just after 3 weeks, so it's going to be the respondents to file their affidavit in opposition in the matter. After 3 weeks.
Obliged, date may be given, Lordship. Date may.
No, you file within 3 weeks, means 3 weeks for you.
Obliged, Lordship.
48.
May I please, Lordship? Extra copy yet to serve, Lordship, that's why. Extra copy yet to serve, Lordship.
Not sir.
Not serve, Lordship.
Already I have first. No, no, no.
Notice was issued on 14/3, Lordship.
Also, I also not received.
Not received that.
So you cannot communicate it.
Also, it's a representative. Mr. A. Chakravarti, I mean, come to advocate. And Mr. J. M. D. Candidates also for the.
That's one.
Standing also for responding to one. And who is appearing for others? Accountant General. I've submitted that.
Four.
I've submitted that the extra copies of the registration has not been served on there. We grant 2 days time to the learned counsel for the petitioner to serve requisite extra copies of the registration to the learned government advocate and the standing counsel for the respondent. If not already served. And to produce a proof of service before the court of the next date of the state. This talk was 6 weeks, everything. 6 weeks. Response by the respondents.
Oblast.
49.
Yes. Similar judgment was passed.
Lord, this is a covered case actually, Lord.
Sorry to ask him. No, sorry. Yes, supernumerary approach. Good question. Into one to talk about recent February. No, they get to say it. India. Recent. Photograph number. But Mr. S.G. Roy and the counsel for the petitioner. And Mr. S.S. Roy and CGC appearing for the respondents. The case of the petitioners is that pursuant to an employment advertisement dated 21/7/2018 issued by the Staff Selection Commission for the recruitment of constables within bracket general duty bracket closed in
Central Armed
Police Forces within bracket CAPF small s for short bracket closed National Investigating Agency within bracket NIA for short and what is SSF? What is SSF?
Seema Sasastra.
SSB, your lordship.
It is the
Seema
SSB.
Suraksha Bal, your lordship.
Seema Sasastra Bal.
Seema Sasastra Bal, sorry.
Within bracket SSB. for
Yes,
short.
lordship.
And rifleman within bracket general duty bracket was in Assam Rifles, 2018. Whereby 54,953 vacancies were advertised. The petitioner who belongs to an OBC category had applied and was successful after availing the benefit of relaxation in the height and chest, which is available for unreserved category candidates for the state of Assam. Full stop. It is posited that on merit, the candidature of the petitioner could have been considered under unreserved category, as the petitioner had scored higher than the reserve category candidates.
Yes.
Last reserve category. No, not last.
Unreserved.
He scored more than
Reserve category.
General category.
General category. Your Lordship.
General category, you get more than
he
general.
scored more than the general category candidate. Last general category candidate.
Yes.
Last general category candidate. Full stop. Next paragraph, therefore, comma. Assuming his non-selection, comma, the present petition has been filed under Article 6 of the Constitution of India. Next paragraph. With regard to the facts of the present case in hand. I find that the case of the petitioner is squarely covered by the ratio laid down in the case of Gaurav Pradhan, GAURAV, Pradhan, PRADHA, and others versus State of Rajasthan and others within bracket 2018, bracket close 11 SCC 352. And judgment dated 1/2/2024 passed by this court in WPC 5212 of 2023. Give a dash. Jintu Mani, JINTU Mani MANI Talukdar versus the Union of India and others. Paragraph number 3. And 48 to 52 of the case of Gaurav Pradhan and others with the Supra. And paragraph 2 and 7 to 9 of the case of Jinto Mani Talukdar within bracket Supra are quoted below. Put this to. Let me see. Accordingly, this persistence allowed. In terms of directions, which are contained in paragraph 51.2 of the Gaurav Pradhan and Grace Supra. Read with paragraph 8 of the case of Jinto Mani Talukdar within bracket Supra. Next paragraph, accordingly, it is provided that the respondents are directed to make a content of replacement against the existing vacancies from if available. And in the event there are no vacancies available for the petitioner from our supernumerary post may be created for adjustment of the petitioner, which is terminable as and when vacancies come into existence. So the accommodation of the petitioner shall be in any CAPFs, public NIA and SSF, SSB and riflemen within bracket GD bracket close in Assam Rifles. It shall be done within a period of 3 months from the date of receipt of a certified copy of the order. However, after verifying whether the petitioner has secured higher marks than the last selected candidate in the recruitment held in 2018 pursuant to advertisement dated 21/7/2018.
Time being item 41 with 42.
Yes. This matter relates to we are seeking a minimum pay scale in the job guarantee up to 60 years. That was given to the NHF employees also SSA. We were appointed by a regular selection process in 2010. Because of which some decisions have already been taken to grant us the job guarantee up to 60. It is page 72. Regarding NHM, they have already implemented. We reliably learned that there is already a cabinet decision regarding that. But
yes, what is your stand?
My lord, I'll have to file a detailed affidavit in this particular case, my lord. However, as on date, my lord, the proposal is under consideration as on date.
No, but you see, notice of motion was issued in August 23. If you want to file it, you do it. We give you 2 weeks further time. Because Mr. Naik, I don't think you will be filing an affidavit.
Lordship, I would like to go through the affidavit filed by the PNRD department, Lordship. Otherwise, Lordship will file, Lordship.
Okay. Also, as a representative. on the prayer made by Mr.
P. Handick, my lord.
P. Handick,
Counsel on behalf of
your government advocate on behalf of the
PNRD, my lord.
PNRD department. And Mr. P. Nayak, Learned Standing Counsel for the Finance Department, raised for and are granted. We make it 3 because of elections. 3 weeks time to file affidavit in opposition in the matter. List after 3 weeks. Make a mention if it is not listed.
Time being item 20.
My place lordship, my matter relates to my promotion of the petitioner, my lord, with retrospective effect, my lord. Now, my lord, already I have retired, my lord, only my lord that for national, my lord, pen, my lord, for that, my lord, I am paying, my lord. Petitioner, my lord, initially joined as a my lord.
You are claiming your promotion from 1412.
My lord.
Why that reason? Why the date?
My lord.
Yes, for BTC, what stand you have taken here with regard to junior being promoted?
Lordship, BTC has taken the stand that earlier he was appointed in the DC office, Lordship. Thereafter, Lordship, after bifurcation, Lordship, he was fall under Excise Department, Lordship. Since Excise is a transfer subject, so we are giving him promotion as per his term, Lordship. We have filed our affidavit, paragraph.
No, he has made a statement that the private respondent got promoted.
Respondent has been promoted by them. Government of Assam. Excise is transfer subject to BTC, so we transferred him as per our Excise Department statement.
Excise is the transfer subject.
Yes, Lord.
No. Then you'll have to tell us. You see, if I've understood it correctly, they said that the appointment was made in the amalgamated establishment of the deputy commissioner.
Yes,
Undivided, Dorong, my lord.
Undivided. Dorong. Now, if you have put him to a transferred department, 2 things. Number 1, whether he's informed that his further promotions will be under the excise department. Because unless you show that he's made aware that his future promotions will be linked to the transfer department.
Lordship, that I do
Where
not have.
is the order of transferring him to the excise department? Where is that?
No, my lord, there is no such kind of order because it's amalgamated, my lord.
No, because you see, you are admitted.
Executive
In your petition, you have admitted that there was an order. But it's not enclosed. In paragraph 5, you have stated that.
Initially, lordship may come to annexure 1, my lord, my initial appointment, my lord.
No. You see, that is one part.
My lord.
The second part is that you are informed that you have been transferred.
My lord.
If you have accepted that.
But
if you
even
have
then, my
accepted that
lord,
position, you're
even then, my lord, the amalgamated that Assam Ministerial District Service will be, my lord, the same cadre, my lord, same promotion avenue, my lord, according to.
No, but it will be department wise. Once it is a transfer department, BTC takes control. It can't be the amalgamated, what you call the establishment will not have control over that employee. He's
But
placed
not-
for the
Not
BTC.
to the BTC, it's a, my lord, my lord, sense of the department by the deputy commissioner. It is not concerned with the BTC. When my promotion came, they said that no, this is excise department is under the control of BTC. You cannot promote him. They're coming later on. Even then, other also deputy commissioner is promoting. if I am eligible to promotion, eligible for promotion, even then they could take it only approval from the BTC authority. It is not that I am not entitled. That they are giving the promotion only for excise department, my lord. The whole, all the amalgamated students taking together as a my lord cadre, they are promoting, my lord. And my initial appointment was not in the my lord excise, my lord. And I was, my lord, appointed when my lord
So where is that
BTC
transfer
was
order
not
of-
created.
Where is the transfer order of 89? You plead that, but you don't annex.
My, অসমীয়া খন দিছো, অসমীয়া খন আছে। I have not annexed my judgment in Assami vernacular, my lord. That my, how I have been, my lord, inducted in the initially, my
Put
lord.
it on record, because otherwise I won't know. I won't be able to give a finding.
My lord, lordship may come to the first, my lord,
Because you
annexer
see,
one page
you
20,
are
my lord.
trying to say that you remain in the amalgamated establishment.
My lord,
And the position is already inter se departmental wise.
it is not transfer, my lord, just entrustment of the excise department. It is not a transfer. Well, from the day to day, you will take the department so and so. This is not a transfer because I'm within
You show us
the control
something-
of the deputy commissioner.
You show us something from which I can find out that this is the position.
That's why, my lord, my initial appointment, my lord.
No, no.
Annexer one page 20.
You see, initially I joined as a lawyer.
No, well, that will
So-
follow, my lord, because
So
if
initially
initially I
appoint-
was,
if you see my initial certificate, it would only be as a lawyer. So thereafter I undergo a process and then come here. So then this, what you call my service law is determined by that.
my lord,
So initial
initially,
entry is not a determining factor. If the transfer order gives you a transfer, it places you entirely under the BTC.
my lord,
I don't know, because this is something where I am weak.
my lord, the amalgamated establishment, all the four departments, my lord, they are not transferred, just entrusting the department, my lord.
Show me something from
So,
where I am.
My lord, lordship may come then, my lord, rule, my lord, Assam Administrative Service,
Yes.
that rule, my lord. Assam Ministerial District Establishment Service rule, my lord. Lordship may come to, my lord,
No,
2-4.
you see, for me, having very limited knowledge in the service
No, my
law
lord,
parlance,
no.
let me ask you two things. Number one, so far as I am concerned, I understand that the person is placed under a department where the DDO gives him a salary. Every department has a DDO. In the High Court establishment also there is a DDO. And therefore, for the practical purposes, one is said to be in the department where the DDO exercises power. Now if the BTC is giving you a salary, that means your service is placed under the DDO of the controlling department under the BTC. So once that is altered, then for all purposes you are in the employment of the BTC, not under the. You may be placed with in the office of the deputy commissioner, but the department which is under control of that excise is the BTC. That's what I understand. If I am wrong, please explain it to me.
My
The
lord,
DDO is not the deputy commissioner in your case. It can't be.
the deputy commissioner, my lord,
DDO.
my lord.
It can't be.
Because, my lord, the BTCs only control other the who are employee of the secretariat, my lord. There is a full control of the BTC, who are the department, my lord, within
Oh,
that
no,
district.
Mr.
The
Deepak Bora
control of the state, my
No,
lord.
no, Mr. Deepak Bora said that you draw salary account from 2039 excise.
That is true, my lord.
So if it is excise, it will be the BTC. DDO will be BTC. Your salary would not be made by the DDO, which is the deputy commissioner, district commissioner now. He will not be making a salary.
My lord, it is not by the secretary from Kokrajhar when releasing the salary. It is the head is, my lord, BTC, it is a deputy commissioner under whose authority salary have been paid. It is not by the any officer of the Kokrajhar, my lord, the secretary of the
You
BTC.
see, that's his instruction. If this is wrong,
In fact, their own writ petition, if your lordship goes to the page, annexure 6, page number 35.
33,
35.
35. Just give it to Saranya.
Of course, this is the draft list which they have annexed. The petitioner's name can be found at serial number 19, Lenin Musari,
Yes, 19.
Lenin Sundra Musari, Junior Assistant, Excise.
But
Head
you
of
are, what do you call, you see,
And the private
no,
respondent.
no, just a moment. Okay, yes, Mr. Sarania.
My lord.
Paragraph 4 of the affidavit in opposition also says the same thing. Our respond number 2.
They have not finally replied to this.
But because of bifurcation of the my lord, different administration the BTC my lord, which are my lord amount of 40 subject transferred to BTC. They have only my lord in case of new appointment they can have the authority to appoint my lord. In case of my lord,
No, it can't be acceptable argument. The reason being, the amalgamated establishment of the deputy commissioner existed before the formation of BTC.
BTC my lord.
And therefore, once BTC is formed, they divide the employees 50-50. 50-50 means it's just a.
My lord,
I
maybe,
love-
my lordship,
because
I
I love
understand, maybe
Crytek, I am
50,
saying
but when
50-50.
promotion comes, my lord.
No, no, no. You see,
One I believe.
you see, when it's a transferred subject, like for example, this establishment of Dimasa Autonomous Council or NCA Hills Autonomous Council, all the people who are placed within the administrative domain of this council get payment from the council, not from the state, although they were erstwhile under the establishment of deputy commissioner. This is something which I have dealt with. If I am wrong, just tell me, because service law is my weak point.
My lord, these
I'll
are,
be-
my lord, the promotion and all this is my lord, only with the district my lord, service rule, my lord. So drawing salary does not mean that my lord, he has a different law, set of law for promotion.
No, just tell me,
Because,
for example, just tell me,
Parliament.
just tell me this one man, A, he is placed with BTC. Now for some reason, government likes this person A. State government likes this person A. What they do is that they will give an out of turn promotion to this man A, bring it out from department A and bring him to department B, and then takes away the employee from a BTC. I don't know if that can happen.
My lord, I admit, my lord, the excise department is under the control of BTC. So promotion has to given on the basis of the, my lord, the service rule on the basis of seniority. Seniority, if I am senior, if I am entitled to promotion, if it is under the control of BTC, deputy commercial sec, approval from the only BTC authority. It is not that BTC authority will, because the BTC authority will promote me, my lord. Because of that, the deputy office of the deputy commissioner is not under the control of the BTC, my lord. Recently, after new agreement, my lord, only recently the revenue department has been, my lord, transferred to my lord, BTC, my lord. Earlier, my lord, the control was with the, my lord, state government, my lord. Only, my lord, in case of salary, my lord, the amount of the head is goes to the BTC, my lord, head, even not go to the accounts of the, my lord, BTC, my lord. The head is for the BTC.
Very difficult to accept. There is another example I can give it to you. Let us say that there is an ACS officer. He is promoted to IAS. After promotion to IAS, you are trying to say that the state government will promote him by taking consent of the central government. Can that be done, Mr. Chaudhary?
My lord, that UPC's approval is required, my lord.
No,
In
because
case
he
of
is no
IS
longer-
promotion, my
he is no
lord.
longer in the state cadre. He will not be a IAS officer, ACS officer within the administrative control of the state government. He's placed with the central government. Once he's a promotee IAS. Don't know, it's something I
Except
can't.
the, my lord, drawing of the salary here, the BTC have no control with me, my lord. He's the deputy commissioner under whose control me, I'm working, my lord.
It just shows something because otherwise I'm handicapped.
Lordship, I am coming, my lord, one by one, my lord. Lordship, may first, my, I can place my
You show
facts.
that BTC establishment, where is that?
2003.
No, you have that that act, BTC,
My constitutional,
constitution of BTC.
my lord.
I did not bring.
But since you are the council for so long, you must be knowing it by heart.
Lordship, normally transfer in case of promotion, Lordship, grade 3 and grade 4. BTC has authority, Lordship.
Who will look into the transfer?
Promoting and in
Promotion
case
and
of
transfer.
promotion and transfer, grade 3 and grade 4, BTC has own authority, Lordship.
No, but it can't be. Because what you are saying doesn't make sense. You transfer, you promote grade 3 to which, where? If you have limitations for transfer of grade 3 and grade 4,
We have own BTC.
no, I understand. But let us test your answer. You have the power to promote grade 3 and grade 4. You will transfer grade 3 to where? If grade 2 is not within your control.
Within the BTC area.
Within
BTC area.
Within BTC. No, you say that your grade 2 is not within your control. You are limiting your transfer to
3 and 4.
3 and 4. So where will 3 be transferred or promoted?
My lord.
No, please have clarity because here there is no
But
clarity.
the promotion as per his turn, Lordship, there is no doubt, Lordship. We are.
No, if he doesn't get a turn, you give him an MC, what do you call, MECP or what MCAP, what do you call?
And Lordship, he has approached honorable for.
He must have a short career progression. You can't stop him from
My
progressing.
lord, earlier lordship will pass an order, my lord. Similar, I am not bringing to notice, my lord. I thought I'll bring letter on my lord. His petition has been allowed, my lord. Same person, my lord. Similar situated person, my lord.
Take it out to be prepared. Bring all those things.
My
Transfer
lord,
if you are
my
saying.
promotion is governed by the, my lord, Ministerial District Service rule, my lord. So they do not have any rule. PTC own rule.
No,
So,
they will definitely have it. There must be a-
they may follow, my lord.
No.
They may follow.
They will have an OM where they are adopting this some ministerial service rules. Because they will have a what do you call? They will have an
They have
what do you call?
no own rule, my lord.
No, they may not have their own rule, but they'll adapt. There will be an adaptation in the
Adapt,
law.
if it is adapt, my lord, with all the cadres are same, my lord. Or for amalgamated
Please
department, my
bring it
lord.
before us. Please bring it before us. We are
I'm
telling
drawing a
that-
different salary, my promotion.
No, I'm not saying that you are wrong. Have I said that what your submission is false? I have not said that. We have to produce documents to
Your
us.
Lordship, if I may just clarify the whole issue, Your Lordship. The petitioner, he was working as an LD in the excise branch of the Deputy Commissioner's office. Now, that particular Deputy Commissioner's office, as we have stated in the affidavit at paragraph number 4, that the petitioner is an employee under the head of account 2039, which is the transfer subject of the BTC. We had in fact earlier promoted him. So if your Lordship goes to page number 38, Annex 7.
No, just tell me
The
now.
DC office.
You see, we don't have, we don't want to be adjudicating on those. The only issue is that who will promote the petitioner. That is the only issue.
Yes.
So what you have done, whether you are head of account A, B, C.
No, I'm not on that. I'm not on that.
Yeah.
So basically, he was promoted by the DC office unknowingly. On 8/7, Your Lordship may kindly note down the dates, Your Lordship. Here, he's
2009.
challenging. No, if I may just complete. Here, he's challenging at page number. Page number 28.
Mr. Bora,
Yes, Your Lordship.
it will take me nowhere. The reason being that your placement, you see, once you have placed him before the BTC,
Yes.
you'll have some document.
Yes.
please produce that document because otherwise I will not be able to appreciate. The fact is that you are placed him somewhere. Unless we read the document, we will not know on what terms you are placed. It may be a temporary placement before the authorities, therefore, once you place him, let us say for deputation, what happens? You send him to establishment B, the DDO is different. But he retains his seniority in the parent department. So the placement of somewhere will not create a contract. The contract is with the principal employer.
Yes, I understand. I totally get it, Your Lordship.
Well,
Basically, I had a telephonic conversation with the DC.
No, that's
So,
okay. You may know, you see, you may know so many things. But the fact is, unless I have the knowledge, I won't be able to write in the judgment.
So, yeah, I
If I have
understand.
to author a judgment, I must know things.
I understand, Your Lordship.
My lord,
So basically, I had
case
a talk
44, my lord, last paragraph.
I had a
of my
talk
lord.
with the DC office officials, and they had told me that he was drawing salary from the excise branch right from the start of his service career.
Maybe we are not saying incorrect. But when we are to presume, please always understand that
Yes.
I come from a background where
Yes.
I read illustration E of section 114
Yes.
of the Evidence Act. Every official and judicial act must be presumed to have been done in a proper manner. So that proper manner you have to demonstrate. Otherwise, you are hit by 114G. A document in your favor not produced will be presumed to be working
Yes.
against you.
I'll produce that particular.
Ah.
Very well.
May I, my lord, one paragraph, my lord.
No, it's
That is
okay, we'll take it up some other day. No, no.
The deputy commissioner himself, is, my lord, in his, my lord, forwarding to the PTC
Let
return,
us
my
say,
lord.
if I have not understood, I have not understood. How much time? 2 weeks time?
Your Lordship, after counting, Your Lordship, 4th June. After counting 4th June, counting is the counting of votes, Your Lordship. 4th June.
Oh.
After that, they will be free. DC office,
4th June.
4th June,
They fix it on 10th June then?
Your Lordship.
In the meantime,
I'll try to- I'll try to-
it's only a document to be produced.
Yes, yes.
I'll try my lord records, my lord, relating to my entrustment because I do not have any document because of entrustment.
I'll
my
try
lord.
to get both of
It is-
them, both records.
It is
as
not
well
a
as the-
transfer.
Outside are represented. Mr. D. Bora, a government advocate, as well as Ms. R. D. Bora, then standing also for the BDC, are directed to produce the document by which the service of the petitioner was placed under the administrative control of the BTC. Stop. The state as well as the BTC shall also apprise the court as to whether the service of the petitioner under the BTC is in the capacity of a deputationist or not. Correct? These two information. The learned government advocate as well as the learned standing officer for the BTC shall send a downloaded copy of this order to obtain instructions for the next list on 10/6/2024.
Even if I am deputation also, my lord, when my term comes.
No, that's okay. Then we understand where we stand.
The thing is that, my lord, the service governed by the my district ministerial service rule, my lord.
No, I still give you an opportunity. If you
My lord.
produce documents before me till 4:30, I'll take it up.
My lord.
But without documents, I have many
Not
queries.
because last 2-3 times, my lord, even learned friend took time to produce the record, my lord.
Yes.
And when instruction.
No, record was never directly
Reflected in the order.
I don't know. I've closed the file. I've closed the file. I have lost track. What I read.
Record never.
Item 21.
Instruction, yes, I placed that instruction.
Item 21.
21.
Mr. Dasgupta, I think we'll have to accommodate you. Day after tomorrow, you wanted?
A little bit, yeah.
Huh?
After tomorrow, it will be a bit difficult for me.
Just now I will speak.
Agree to a date, both of you.
Oh, Lord, then next week, Lord,
Give a date. There's a calendar before you.
Right, this is
Just now I will pick a date.
14 minutes.
It's okay, because again, if it takes time, I don't want to
Let it be on,
detain you.
let it be on 14th of
Just see the
Tuesday.
continuous, let Mr. Dasgupta come here. 14th is okay?
14th.
Okay, 21. The paucity of time, the matter could not be heard today. List on 14. 5.
14/5.
2024. So the court will make an endeavor to hear the matter on this date.
Yeah. Then let it be on 17 minutes. I'm sorry.
Just agree to agree.
Let it be on 17.
17.
I'm sorry.
Yes, Mr. Sharma.
In this case, madam, I have challenged the appointment of the respondents, private respondents, as well as the selection. There was an advertisement in the newspaper, madam. That is from 3 to 15. There was an advertisement for 2 posts.
Where is the affidavit filed by the respondent number?
My lord,
This Industries Department, where is your affidavit?
Lordship,
Industries Department?
Yes.
When did you file your affidavit?
it was filed on 11th of July.
Your respondent
2016.
number? Your respondent number?
Industries, Lordship,
number 3. The respond number 3.
respondent number 1 and 1, 2,
1, 2, and 3.
1, 2, and
1,
3.
2, 3.
And 3 has filed the affidavit.
Just a moment. There is an allegation made in this writ petition that the evaluation of the answer sheets were done on 7/4.
Yes.
2015, but the minutes of the evaluation was signed on 30/3/2015. Have you denied it? Because I have missed out if you have denied it. This is, that is not denied. The appointment of respondent number 4 would have to go, and then fresh exercise has to be undertaken.
Unfortunately, that has not been specifically denied, Lordship.
The writ petition has to
But
be
the
allowed.
records are there with me, Lordship, but the record shows that it was happened on that day only.
He's got an
It-
RTI reply.
It has been signed on that
No,
particular date.
it's okay, but his RTI reply is says otherwise. Shows your records. Let us see.
Lordship.
That is the only point. And this Viva, there are signatures of how many board members there? The Commissioner said that it has only two.
Out of 5, only 2 signed.
Yeah, actually, lordship, like they have given the marks and all individually they have marked, individually they have signed, but in the minutes lordship, 2 have signed.
Then it goes, it can't be saved.
The statement, lordship, they have made a statement, a chart. In the chart, like functional manager and GM has signed. But like,
If the
that-
assessment sheet is not signed by all,
but lordship, there are, I mean, the kind of a mark sheets they have given in a tabular format. So there, lordship, all the members have signed. That is there on record.
does it contain any endorsement why two people have signed? No.
Lordship?
Have they given reasons why two people have signed? No.
No, nothing, lordship, nothing that's,
Then you can't save it.
nothing that's all.
Because in the annals of the legal jurisprudence, from my limited research, I have found only one decision of the courts in India where two judges had heard the matter and one judge delivered the judgment. And it's a leading case cited by, I think you have also cited it. But the reasons were given, why one had to sign it.
Correct, lordship.
If the reasons are not there, we possibly can't save the appointment.
Otherwise, lordship, what has happened, lordship, there was a selection committee they have constituted. Then for 3 exams, actually like one written test, then one computer test and one viva voce. So three separate committees have been constituted. And they have checked all these things. All these things are there on record. But as Lordship has pointed out, as far as viva voce, Lordship, they have made a chart. Individual marking has been given in different tabular formats. But in the chart wherein like the whole marks were given, there Lordship 2% absent. That is correct. But this is there, other Lordship, those sheets were
No,
there.
you see, there's a different reason why I'm asking only one pointed question.
Well, Lordship.
Unfortunately, again, the question relates back to my previous experience. You see, the original mark sheet is always the original one. A tabulation made out of it becomes a secondary evidence.
Correct, Lordship.
And the secondary evidence to become primary evidence,
That has to be.
signed by all.
Right, correct.
So therefore, once that extract is signed by all, then it becomes a primary evidence. That means all the persons take responsibility of that. If tabulation has only 2 signatures out of 5, I don't think it can be
What they may have done it, Lordship, they have copied the marks and like chart has been prepared and 2% have signed it, other people haven't signed it. That is what record says.
Who is appearing for respondent number 4? Private respondent who's
What do you
And Sharma, my lord, he is next in some other court, my lord. I appear for R5. So far as R5 is concerned, my lord, I have filed an affidavit.
What
There
is
is not
said?
a single whisper of any allegation against R5.
No, that may not be, but the entire process goes by the manner in which it was done.
It's true, my lord, but R5 has bona fidely, my lord, participated in the selection
No,
process.
nobody is attributing anything against 4 and 5.
No, 4, my lord, there is.
No, the 4, there is some allegations.
Oh, there is some allegation.
No, my lord, the very edifice of the repetition is, my lord, that malafide has been alleged against R4. And not a single whisper of allegation is made against R5. And to that extent, my lord, I have filed an affidavit. And there is no affidavit in reply to my affidavit.
But if the process goes, everything goes, lock, stock and barrel. Nothing can be saved, even if you are not at fault.
On technicalities, my lord, if my lord, we express it through a further space of imagination, and my lord, we say that on records. My lord, say for example, what has fallen from my lord, that it ought to have been signed by a definite number of members, that was not done. That is the irregularity, my lord, I admit, that is the irregularity. But because of that irregularity, my lord, whether the entire selection process would be vitiated against R5. Because R5, there is no allegation, my lord. Lordship will kindly peruse the entire body of the writ petition right from paragraph 1, my lord, to paragraph 19. There is not a C. And even in the prayer portion, if my lord may be please to come to page 16. Page 16 of the writ petition. I'm traveling, my lord, with all these pages. In the prayer portion, it is only at the very beginning of the prayer, lordship will find, my lord, as to why the appointment of the respondent number 5, vice so-and-so and why that should not be cancelled, set aside. And also, sir, after hearing the parties, may be pleased to cancel the appointment of respondent number 4. So evidently, this is a typographical mistake. Evidently, my lord, the prayer portion, my lord.
It is 5 and 4 both,
No, my lord, 5 at the beginning, then 4.
then 4.
Then 4. Then, my lord, in the interim also it is 4. So we have to necessarily read it as to be, my lord, to be meaning of only R4, not R5. No, lordship, kindly say, my lord, we are before a, my lord, before a court of record. Kindly say, my lord. It is therefore prayed that your lordship would be pleased to admit this writ petition, call for the records and issue rule, directing the respondents to so cause as to why the appointment of the respondent number 5, why notification so and so should not be set aside so and so, and as to why the appointment procedure should not be questioned for so and so. After hearing the parties, may be pleased to cancel the appointment of R4. After hearing the parties, to cancel the appointment of R4. So where does my lord R5 comes in? And in the interim prayer, kindly say, my lord, pending disposal of the petition, be pleased to restrain the respondent number 4 from discharging. It is not, my lord, not a single allegation has been made against R5. It would not have been the case also, my lord, for the writ petitioner. Because, my lord, the writ petition is founded on the allegation that, my lord, the selection committee members are, my lord, close relatives of R4. That is
Not even that, the allegation is that respondent number 4 is the father of.
Yeah, that was
father
the
of
allegation,
respondent
Lord.
4.
That was the allegation.
He collected the answer scripts.
He collected the question papers along with the, I mean, model answers maybe. So that, but the father hasn't been made a party here.
No, may not be.
Some
Allegation-
malafide has been, I mean, it's an allegation against him, serious allegations.
No,
against him.
it's not required. So this is something I are not denied. Let respond for Mr. Sharma, you said. After some time, just wait if I have time. What the order matters?
Some, lordship, some, technical irregularities are there. That's admitted fact, lordship. But whether entire process will go after so many years, lordship, that's lordship has to say. Almost 7, 8
I
years.
don't know, I got enlightened only when we took up those APSC matters.
Irregularity ground for illegal appointments. The appointment illegal.
So here it's irregularities actually, they're not exactly illegal. The committees were there.
It is correct. There were, my lord, allegations per se, blanket allegations and allegations, pinpointed allegations in each of the
candidates.
Each of the candidates. Here is a case, my lord, there where there is not a single allegation against me. And I am protected at least under the provisions of Article 16, my lord. State has, my lord, selected me.
Let us see. Respondent four is called. Four is called.
Yes, Your Lordship.
Sit down, take a breath.
Yes, yes, yes. Yes. If I may start, Your Lordship, yes.
This will tell you,
Yes.
neither the petitioner's side nor the respondents have argued. We are only on one question about the proprietary, procedural impropriety done in the selection process, which according to us vitiates the selection process. Number one,
Yes.
your father went and collected the answer scripts and the question papers, number one. The second is that the final tabulation is signed by only 2 persons when the board was of 5 members. That itself vitiates the entire procedure. That is the query of the court.
There's a query. I'm walking on very thin ice here in this matter, but on a very technical ground, Your Lordship, the advertisement was dated 3rd of February 2015. Then there are 3 stages that happened. The written test was held on the 18th of May 2015, which is at Annexure 3, page 22.
On
Written test on 18th of May 2015. Your Lordship sees them. Yes.
Yes.
Now, those who were selected for the written test, all of them were automatically asked to come for the computer
So
typing
here
test.
again, there's it appears that the petitioner's allegation
Yes.
leads towards some, I won't use the word, I'm temporarily using the word irregularity, but it may not be irregularity at all.
It might be a more code
It
form.
might be more,
Codes in,
more harsh than that.
crude form. Yes, yes, I
Okay.
absolutely understand.
The evaluation of the answer script was done on, the dates are important, 7/4/2015.
Yes, yes.
But the evaluation sheets were signed on 30/3/2015, predated. So marks were predated, then evaluation was made thereafter.
The minutes of the meeting was signed on 30th. And like
Not have-
they have done it
when-
later on.
When you check the answer script in April,
Okay.
you can't have a minutes made on 33.
Absolutely, not the record says, absolutely.
I'll try making a submission here, Your Lordship. That based on the selected candidates from the written test. there-
No,
Yes,
this is the case where candidates were selected, then written test was examination. Then written examination was evaluated.
but
Candidates
also-
were selected, no doubt. Transparent process.
yes.
Transparency is there. We are not saying there is no transparent process. Candidates were selected, then
Yes.
answer script checked.
That again, Your Lordship, that's putting the cart before the horse, but there's a mere technicality here, Your Lordship would like to entertain here. That the petitioner at paragraph number 3 at page 5
Yes.
has made a submission that the petitioner had also duly applied for the post and she had been qualified in the written test held on 30/3/2015 and had been asked to appear in the computer/typing test in Viva along with 8 others, and her position was serial number 6 in the notice dated so and so. In the written test, the position of respondent number 4 was at number 1, which is quite surprising considering his poor merit in academic qualification. This paragraph, Your Lordship, it leads to an apprehension from the petitioner side that the marks which are allotted to the respondent 4, respondent not 5 here, respondent 4 particularly, and the petitioner
are at loggerheads with their academical credentials. Thereafter, Your Lordship, the petitioner proceeded to participate in the selection process. Now, until and unless my learned senior friend for the department satisfied this court that there was no impropriety, the fact that my learned senior for the petitioner participated and went ahead and thereafter turned back and challenged the entire process. Again, Your Lordship, I'll submit that in the absence of any impropriety. Yeah, that is not
I'm
for
just
me to-
speaking aloud.
Yes.
At times I go astray. Forgive me for that. I have peculiar examples. You see, while interacting with you, I'm smiling towards Mr. Kalita, and I'm also extending my smile to Mr. Arkady Chaudhary sitting behind. Correct? It's just an example. So, whether this is enough for you to start a protest that, look, when I am arguing, the honorable judge was more interested in my right, and therefore he had a prejudice in mind, and therefore I will not argue. I'm just thinking aloud.
Yeah, yes.
When you are making a submission, I'm
Yes.
smiling at Mr. Kalita, extending my smile to someone in the back. But can that lead to an inference that the judge was prejudiced at the time of hearing and was diverting his attention towards someone in the right and was not concentrating on my argument?
Now, if Your Lordship had expressed Your Lordship's observation, then I may have had that ground. Here, the
No.
mark sheet and
No,
the
because you
evaluation.
see, no, the reason is very
Yes,
simple.
Yes, yes, yes.
That in course of interaction at the time of hearing, you'll find it very interesting. We have shown it many times. I'm giving it to you again. This is something I just can't. Refrain from smiling when I'm reading it. See this. Two things I'll show it to you. Before the page I am turned, you come to page 165. Come to 165. No, this.
Yes.
Section 165.
Section 165. Yes, sir.
Yes.
If I may read your options. 165, judge's power to put questions of order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant.
Yes, please stop here for the moment. Therefore, judge has the power to ask irrelevant questions. Therefore, questions asked at the time of interaction made during the time of argument, when both parties are addressing the court, it may be irrelevant, but the fact is that the judge has the power to ask questions. Therefore, you can't say that once you have asked questions, you have shown prejudice against the interest of the petitioner or the respondent, and therefore you recuse from the case. That is an argument is not permissible.
Absolutely, absolutely.
Correct. So therefore, nobody, the second thing is, no lawyer who is well acquainted in the art of lawyering will be happy with a judge who is silent and non-interactive. Because you do not know what is hitting you. It's only to only in order to elicit information from the lawyers about the facts of their case. They're just interacting, because if I come with a predetermined mind, then you will find it's you'll all go out and say very hard nut to crack. So therefore, when we are hearing, it's not a question of prejudice expressed. It's a question of asking question which is permissible within the meaning of section 165, and asking questions which may be relevant or irrelevant. But when I add up two irrelevant things, in my questioning, you will come to know that they are otherwise relevant.
All these questions, your lordship has put in, those are relevant questions, all of.
No, no, it may be irrelevant because I have a very bad way of when I cross-examine, Mr. Sharma will know it. It was study in a long cross-examination. And I would not go in a sequence. I don't
Situation
enter a
demands.
sequence. After asking father's name, I will not ask the age. I may ask something different, and then third question maybe I am asking his age.
That is
So-
the art, lordship.
No, that's not an art.
Now, maybe lordship has
But,
adopted that.
That's not an art, but it's the way I adopted myself.
Yes, adopted.
So that's one part. But Mr. Sharma, the bottom line is there's these 2-3 questions.
Yes.
Apparently, there's no answer. Because once a memorandum is made on 33, it means that the evaluation process should have ended on that day. And if the answer scripts
Yes.
evaluation was done on 7/4, it's gross irregularity or illegality, if I may say, permitted to say so. And this is something you can't say.
Yes, lordship, in the chart, lordship, what has happened, they have written a statement of result of written test held on 33/2015 for the post. But whereas in signing this, they have written 7/4.
7/4.
That's there on record. And like that, and then the minutes was signed on 33.
So that's right.
Minutes was signed on 33 only, but like the statement, like they have made signature on 7/4. That's on record.
No, yeah, fair enough. I have no grievance with once you say it fairly. But Mr. Sharma, it has to be redone again. Can't be saved. This also gives you an idea of what is happening.
Paper will be made on vaccine issue. The last paper will be made on arguing on the principle of vaccine issue.
Vaccine issue.
Whether the vaccine issue might not project any adverse kind of inference against.
No, if you can show to us that you see, when I'm signing, my court staff attached to me, the staff attached to me is my usher. I don't know about his educational qualification. I've never asked him. But they make it a point when I'm signing, they will tell me, sir, you are signing on a wrong date. Today is 8th and you are signing on 7th. Because yesterday, if I am signing any document 7th, I'd come today, I just miss it, I write 7. And then he will correct me that you wrongly typed it. And he does few checkings. He will see that the order is typed out in the right retention number. Because it may so happen that in copy paste, I'll be signing on WPC 1 of 2024, whereas I am taking up item number 2, which is WPC 2 of 2024. So this mistake in similar orders happens when we cut paste the orders. So at times it happens. So I'm corrected by my staff whose educational qualification even I have never asked. So he points me out those mistakes.
Correct.
Correct. So I may make a mistake in giving a signature and I'm correcting it. But today when I'm signing on 8/5, I'll not be signing on 35.
Maybe one day here and there.
Maybe one day here and there is okay. Or it may happen that, well, I am accustomed to write 23. So I may write 8/5/23 today. That is likely to happen.
Yes, lordship, I understood. Like, I mean, that's not so many days. So therefore, even if there is a vast discrepancy between the signing dates and when it was prepared, lordship will definitely would like to draw an adverse inference because the chain of events will have to be evaluated. Because if the whole selection process goes, my argument would be that if it is an irregularity, not attributable to me, and doesn't spring up from any malice against me, that can I be state even if the selection process goes.
No, you see, I'm just taking a cue from your argument and I'm just putting things on. I think there was a repetition here when it says that when there's so much of anomaly in the selection of the APSC selection, why the entire selection should not be set aside? And I think there's a verdict of this court saying that there are specific allegations against these persons and therefore the other appointments are not disturbed. So there's a reason given. And that is not based on the fact the signatures were made on different dates. It's based on the fact that against certain candidates, there are allegations, there were about 10 allegations mixed up with individually with 1, 2, and 3. So that was the reason given. And therefore the court justified why the entire selection process of those years should not be set aside. So I'm just taking cue for it and testing it. So I find that this court has given an answer in one of these cases to why the entire selection process was not set aside. But when there is a error in giving the dates of the evaluation of the preparation of the evaluation sheet, then even if you are not at fault, it is the procedure itself which is the selection process, the procedure adopted.
Sufficient engagement will be a procedural irregularity. For example, in district forum, another consumer protection act, there the act prescribes that for the state commission or the district commission, one person would be appointed as the chairman, others will be members. Provisor is there, nothing will be prevent that if there is a illegal, irregular constitution, if any the chairman is, the post of chairman is vacant, other 2 members, then it will not be shared. It is within the statute itself. The principle is that my respectful submission, the principle is that if the wrong cannot be attributed to me, primarily by a man of ordinary prudent reasoning, then I may not be my rights cannot be curtailed. Because I am selected. I have gone through a definite selection process. Maybe irregularities, lot of irregularities. I have bona fide participated. It is not that since the date of my appointment till now, I have been rendering my services to the satisfaction of all concerned. I have my family, if my services is outstanding at this moment, I will be nowhere. I am not opening up that argument in this matter.
After having said so.
Therefore, there's some facts in it. So what are the facts before to decide? Facts in whether the facts might not inspire the confidence of this honorable court to outs me. Whether that irregular signing on various dates is attributable to me. If there is any material of record to even to remotely suggest that yes, it is attributable to me, then definitely I would be outside. So therefore, the repetition is reminds it is drafted in an exam that the whole irregularity has been attributed to R4. I have filed my affidavit, and against my affidavit, there is no result. Exercising powers under 26, whatever we have before a court of record.
Okay, I'll consider that. What is it, page 31?
38.
You see, Mr. Karita,
Lordship.
page 31.
Yes.
This Sildama Ungo.
Yes, Lordship.
লিখিত প্ৰশ্নসমূহ হাতৰ পৰা জিলা উদ্যোগ আৰু বাণিজ্যিক কেন্দ্ৰৰ হৈ কোন সংগ্ৰহ কৰিছিলে?
Correct.
Now the reply is at page 32.
Yes, Lordship.
Now the reply is that general manager collected.
So basically, Lordship, it's a general manager's office. He has entrusted two
General
other
manager's
persons.
office and general manager, because you see the allegation is against his father.
Yes, yes.
Having collected it.
Lordship, that has been later on, they have asked for some other information. And therein, Lordship, that information has been given. That two persons have collected it. That has already been given. And one person happens to be the father of this one number 4. That's not denied, Lordship. That is correct. But that's on record, Lordship.
Okay, let me examine it in class of this.
Page
Anything more, Mr. Sharma? Anything more you wanted to say?
Even the final selection committee, one of the members says that I was never a member of it.
Where is that?
That is
That I missed out.
As come, Your Lordship, page 62.
yes, come.
Page
62.
Yes, Your Lordship.
Even is the is
Page 62, Your Lordship.
61 is the actual RTA reply.
Here,
The
Lordship,
RTA itself is, but firstly he written. In vernacular he is written. Thereafter he's firstly page 61. Thereafter he has given one letter also. It is page 62.
So,
He said that he was not member of any of the committee.
so as far as this document is concerned, Lordship, I have really only one small submission, Lordship, because this person was not the public information officer of the particular office. It has been written to him and he has written directly to them. Yes. So he is not authorized to write this letter. Because it has not gone from the
Once
public
the
information.
arrow is out of quiver.
That is good. So this only that he has obviously Lordship, he has admitted that. But only thing is that Lordship, he is not a public information officer. Designated public information officer
Cannot be, but
hasn't replied to that,
but as an institution, you have not
taken any action.
taken, no, not taken any action. You have not denied that he's given a wrong reply. That stand is not there.
That's really not there.
That's why,
It's not there.
okay, I'll pass on, I'm reserving it.
Lordship, we only consider that time period, Lordship, like they have been working for 7, 8 years.
Mr. Sharma and counsel to the petitioner. Mr. For state of Assam, you will be representing, Mr. A. Karita, that person for the Industries Department, appearing for responder numbers 1, 2,
And 3 Lordship.
1, 2, and 3. Mr. M. Sharma, running counsel for responder number 4. And Mr. R. Pujari, running counsel for responder number 5. Arguments are come to the judgment is over.
Section I am relying, my lord. I have just made it.
Get to the court master, mail it.
Yes, my lord. Here 2023.
Just now.
What your report?
Which
Select AI, correction upon
AI?
2023.
It is
AIR?
Yes, AIR 2023.
SC
SC
2014.
2014.
20
2014.
2014.
I
You have the
am-
name of the parties?
Yes, my lord. Tasbir Singh Sodhi. Tasbir, Jack VIR, Tasbir Singh Sodhi,
TASVIR.
Jack,
Z.
Tasbir Singh Sodhi, and others versus State of Jammu and Kashmir and others.
Yes.
Here my lord, I am relying on paragraph 13.1 as per Manipatra versus. Other paragraphs are also there. my lord. It is
13.1.
13.1.
How does it start?
But it is therefore tried that candidates having taken part in the selection process without any demo or protest, they cannot select it. Even if there are irregularities. There are other paragraphs.
Okay.
I have also
Mail it to the honorable court.
my submission of case laws was based on paragraph number 3, your lordship, as I pointed out, that the first grievance of the petitioner arose on the marking which was allotted to my client over and above my senior's client, your lordship. And that it should have been assailed at that point itself. And when the petitioner decided to participate further, he has stopped from turning back and challenging the entire process. Three case laws, your lordship, I had prepared. It was in the bag, your lordship. I can list out the citations also. Yes.
You just write in a piece of paper. and
Yes,
give it
yes,
to the
yes,
court
yes,
master.
yes, your lordship. Yes. But yes, sir. Officer, yes, officer, yes.
Those are reported in AR and SCC or something, somewhere.
These are all SCC citations. your
SCC, then it's okay.
Yes.
There is. The persons tell the points on which those judgments are there, because they may retain some part of it. Just tell us.
Estoppel, your lordship. The fact that a part.
Estoppel,
Yes,
okay.
yes.
All
so
three
that-
are on estoppel.
On these grounds itself, your lordship. Madan Lal versus State of Jammu and Kashmir, Chandra Prakash Tiwari versus Shakuntala Shukla, and Sadananda Halo versus Mumtaz Ali Sheikh. I'll give the citation, your lordship, around the relevant paragraphs.
Which paragraph 3 you are referring to?
No, not 3 paragraph. I was just referring to just case laws I've cited, your lordship.
Huh.
Paragraph number 9 in 1995 3 SCC 486.
No, that you write it.
Yes, paragraph number 3 in this writ petition. In the writ petition. In the writ petition.
Paragraph 3. huh.
Yes, paragraph number 3, where the petitioner was surprised and shocked at the marking which was allotted to the petition to the respondent number 4, in spite of the academic credentials of the petitioner over the respondent number 4, as in the opinion of the petitioner. That was the first leg when the entire process.
But what is that judgment where the Supreme Court has observed that once one consents to the procedure, they consent to the legality of it, not the illegality of it. What is that judgment?
That's fine.
Is it the Abbas case? No.
No, it just one.
So because your lordship would kindly see.
Please for the Madan Lal versus State of Jammu and Kashmir.
It's that.
They said, madam, Supreme Court held that it was in the exclusive domain of the expert committee to decide whether more marks should be assigned. In the court cannot sit as a court of appeal over the assessment made by the committee. That is on that fact.
I just cited, your lordship, I just cited 1995 3 SCC 486.
Yes, 1995 3 SCC 486. It's a widely reported modern law. It is modern law versus state of Jammu and Kashmir. Last submission, madam, where in the decision, madam, monopatra version, which I have, madam, mailed, madam, to my lord. Possible also kindly, madam, mark para 7.8. 7.8, madam, in that,
Which decision?
madam, that year 2023. That,
Just write the paragraph in your paper.
yes, madam, but may I read it, madam? Here, madam, Reliance has been placed on, madam, 2021 4 SCC 631 in the Singh, madam, then 2006 11 SCC. Yes, there are several other decisions, madam, when the FX court has held that those who are innocent of wrongdoing should not pay a price for those who are actually found to be involved in irregularities. And therefore, the selection as a whole cannot be found, cannot be set aside for specific instances of irregularities. Unless there is a systematic malice affecting the integrity of the selection and denying equal opportunity, the entire selection cannot be set aside by taking away the appointment of innocent and meritorious candidates. That lordship will find it,
In your paper, just
7.8.
indicate in your paper.
There's one more detail, your lordship, at page 44. Page 44. Page
Yes.
44 and page 45. These are marks of the Viva Voce and the computer typing test. In both these tests, your lordship, the petitioner had scored more marks, significantly more marks than the respondent number 4. The petitioner's name featured in serial number 6, who have obtained 36. And the respondent number 4's name features in serial number 1.
45.
No, 30, page 44. 44 and 45. 44 is the first page, your lordship.
44 is there.
Yes,
36.
44. Respondent number 4's name is at serial number 1, 16.
Yes.
And petitioner's name features serial number 6, who's obtained 36. Then page 45. The petitioner has obtained 23 and I had obtained 18.6. So there was no illegality or there was no impropriety based on the petitioner's apparent credentials that he was robbed of his marks. If anything, assuming, not considering the fact, but assuming that there was some impropriety that had taken place, it had taken place as mentioned in paragraph number 3, which was not contested and disputed by the petitioner. With utmost humility, I'm submitting this. And now, to assail the entire process based on an apprehension that the petitioner had at that point in time and decided to proceed further in any case, may not hold water at this stage, Your Lordship, after 6 years, after 8 years, after 8 years. 6 years. So the only instance where the petitioner claims that he was robbed of his marks was at the stage where he was completely aware of. Over and after that, Your Lordship, the petitioner has always scored more marks than the respondent number 4. And if at that point there was no complaint against that before the authorities, then maybe now, Your Lordship, the petitioner may not have. That is my submission, Your Lordship, my limited submission. I'll be submitting the case laws to the master, Your Lordship, in due.
And only thing regarding my participation in proceedings. Well, I have participated in the process of selection. I was not willing to participate the illegalities in the process of selection. That is my Lord 2019-20 SCC, page number 17.
Give the name.
It is Dr. Major Mita Sahai versus State of Bihar and others.
Dr. Mita Sahai.
Mita Sahai.
Hi, right. Mita Sahai, that is the case.
I'm not participating in the illegality.
Give the citation in that. Add your citation in their list. Mita Sahai, yes. Dr. Mita Sahai. Yes, yes.
Thank you.
Yes, yes.
Regarding bias, my lord. If doubt is created in the process, if doubt is created, one doubt is found, his father collected question paper with answer scripts. Definitely a doubt, serious doubt in there. Regarding in this case, my lord, this is
just write in a piece of paper and give it.
In this case, mother-in-law was in a selection process. So serious, the court says it is serious doubt. And regarding length of service, the court several citation decisions are there. Length of service is not a bar. If illegality is there, if illegality is there, selection process is illegal. Illegalities are committed. They have decided the marks to be given to the candidates before evaluation. So that is serious illegality. One candidate, one of the selection members says that no, I was not the member. So it is serious illegality. Serious illegality. So serious illegality, there so the bias are there. So I have seen this citation. I'm giving it.
I think for other matters, I will not have time today. Yes, Mr. Dhar, Mr. Chaudhary. Any case where there are interim order to be extended, please tell the court master. This one contempt matter which has come up by orders. There is item 50. Whose matter is that?
My lord, I have mentioned this matter for petitioner number 1 and 2 already appointed, my lord, and their name may be stuck off, my lord. But remaining petitioner, my lord, 3 to 7, my lord, yet to be appointed, my lord. So that is the non-compliance of this honorable court order. And in the meantime, I have to be allowed to incorporate the other respondents, my lord, new incumbents, my lord, by issuing them a legal notice and then implement petition.
Okay. Mr. IRM, then counsel for the petitioners upon instructions has submitted that the petitioner numbers 1 and 2 have been appointed and therefore he has instructions to pray for striking out their names. Mr. Ardhar, learned counsel for respondent number.
No, my lord, I was asked by the
Oh,
court to
okay.
appear, my lord.
Oh, okay.
I'm not appearing otherwise, my lord.
You are not
I wrote
appearing
to file
otherwise.
an
Okay. Why was your presence required?
my lord, none appeared. So by a direction on the last occasion, my lord, order dated, my lord, there was the order dated 15/9, my lord. The court has, my lord, asked me to
Obtain instruction.
obtain instruction as to whether the thing has been, my lord, complied. The order has been complied, my lord. Now, my lord, what I have, my lord, the information that most of the officers, my lord, either they have retired or not in position, my lord. Long back, my lord.
So I may be allowed to, in the meantime, my lord, I will serve them a legal.
No,
notice,
because
right?
there's a difficulty, although we have requested Mr. Dhar to appear, but in contempt
I don't
matters,
have
we
any
can't
Bangla-
compel their appearance.
That is the problem, my lord.
Because
It's a contempt.
at times we are conscious of the fact that he is not a counsel for any of the respondents.
My lord.
But at times we may forget that he is not a appearing counsel and pass on reverse orders. So we'll delete his name.
Yes, my lord. It will be easier for
It will
me.
be more convenient.
Today, my lord, only petitioner number 1 and 2 name may be struck off, my lord.
None based on call for respondent numbers 2 and 5. Next para. Mr. Ardhor Leonard, additional senior government advocate, submits that on the last occasion when no one appeared for the respondents, comma, he was asked by the court to obtain instructions. By the order dated 19/12/2023. He has submitted that as per information received by him, comma, now the respondents are holding the posts which are mentioned against their names. Full stop. The learned counsel for the petitioner shall take note of the same and take necessary steps. So, in view of the response given by the learned additional senior government advocate, comma, as he is not appearing as an engaged counsel for the respondents, comma, this being a contempt petition, comma, the further appearance of Mr. Ardhor as additional senior government advocate is dispensed with. Next para, the registry shall take note of this order and delete the name of Mr. Ardhor as additional senior government advocate in the cause list by listing the matter next. Next para, the registry shall cite start the name of the respondent of the petitioner numbers 1 and 2. Next para, list after 2 weeks. As paid for by learned counsel for the petitioner. Petitioners.
Obliged.
Yes, any other matter?
My lord, I victims of item number 70, my lord. This is a
70.
matter of- 70. Hearing
Yes.
matter, my lord, this is a matter of 2013. Though the issue relates to 2005, my lord. Can we fix on a hearing date, my lord? It's for hearing. This is series, my lord.
This is a serious matter.
Yes, ma'am. All the old matters. my lord.
Okay. Serious matter. The positive time matters could not be taken up today. List on, give a date on a hearing date. Whenever you want. Give it after some time. Any other matters or?
Lordship, subject to what my friend says.
Yes.
Item number 51, Lordship, it's a contempt matter. My friend appears for the petitioner, I appear for the respondents. Lordship, my instruction is, Lordship, it has already been complied with. There was a division bench matter also on the same issue. There was a contempt arising out of the same case. Some money is owed to him that has been paid. If my friend consents, Lordship, this can be closed.
Yes.
My instruction is that, my lord, the fixation has been done. excision has been done by, as per your lordship's order.
Basi.
But my lord, the subsequent pay hikes hasn't been paid to the petitioner.
That he can, lordship, if there is any discrepancy in what he has received, that he can challenge, but on the same issue, the division bench contempt has also been closed, lordship.
This is item number
51, lordship.
51. If the calculation is wrong, you'll have to file a petition, Mr. Saikia.
My lord.
It can't be done in a contempt proceeding.
Yes, your lordship.
51. For Mr. I.S. Saikia and counsel for the petitioner. Next para. Mr. R.K.D. Chaudhary, learned counsel appearing for the respondents, has produced a copy of written instructions dated 7/5/2024 by the Assistant Administrative Officer, Officer in Charge, Regional Legal Cell, GREF, care of 99 APO, stating that the order of this court dated 18/2/2020 in WPC 1537 of 2015 has been complied with by crediting a sum of rupees 86,462 in favor of the petitioner. Full stop. A copy of the payslip for the month of 2023 is also attached.
March
thereto.
2023.
Next para, it is further stated therein that the petitioner has been removed from service with effect from 10/8/2023 under Rule 11 within bracket Roman 8 of CCS within bracket CC and A bracket closed Rule 1965 due to willfully overstaying leave with effect from 22/11/2021. Next para. The learned counsel for the petitioner submits that the calculation done is incorrect and is entitled to a higher amount as
Arrears.
arrear salary. Full stop. Next para. In the said context, the court is of the considered opinion that if the calculation is incorrect, the petitioner would have to challenge the same. Full stop. However, as the respondents have released a sum of rupees 86,462 to the petitioner as total emoluments receivable by him, notwithstanding the delay in implementing the order of this court, but as the order of this court has been complied with, the court has no reason to pursue this contempt petition. Stop. According to this contempt petition stands closed. How we devoted to the petitioner to assess the calculation of the dues of the petitioner and or to pursue his remedy for any of the pay or anomalies due to him. You have a copy of this?
Lordship, I have a copy.
Okay, the instructions in original as produced by Mr. R.K.D. Chaudhary, the counsel for the respondent, is kept as a part of the record.
Lordship.
That's why I just added together with the payslip for the month of March 2023, together with photocopy of the payslip for the month of March 2023 is kept as a part of the record.
So, right, Lordship.
Yes.
Your Honor, may permit me to mention item number 64 and 65. These are matters regarding non-payment of PF dues, where the employer is actually the central government. And there's a batch of almost 1,600, 1,700 petitioners who've not received the PF dues for a very long period of time.
64, 65.
Please, Your Honor. HR payments.
No, but we can't do anything about this because if those are matters of liquidation, once this.
Your Honor, actually the liquidation has already ended. And what had happened was that the EPFO had gone before the NCLT seeking the money from the liquidation estate. But now there's a Supreme Court judgment which actually the order of 9th of Feb also records that order. There's a judgment from the Supreme Court that says that the liquidation estate and the provident fund dues will not be commingled. And initially when the government of Assam was taking over this company, the company in question is the Hindustan Paper Corporation. So when the government of Assam was taking it over, an assurance was given that they'll pay all statutory dues. And to be fair, all statutory dues except.
No, we don't know. In the absence of government, we can't take up.
No, that's absolutely fine. I'm not asking for I'm just saying if the matter maybe had a little higher up in the list. So that
Oh, that we can't do. We can only upgrade and take it up, but I don't have control over the in the order in which it can be listed. Give it on a
shortest date may
okay.
be given on. A shortest date.
Okay, the court master will give you after some time. The pleadings are exchanged in this matter.
The
Why it has come
application
for-
has been, actually the writ got disposed of. These are IAs for restoration of the writ petition that I filed. So this aspect of the provident fund dues didn't get decided. So that has been served on the other side.
Okay, motion day. Okay.
Deeply obliged, Your Honor.
Make a mention for upgrading if you want.